Good morning, councillors. Good morning, executive. And good morning to those joining us in the digital gallery as well as in the physical gallery today. It's my privilege to declare the ordinary meeting of Tuesday, 6th December 2022 open. And in so doing, I would again acknowledge the traditional owners of the lands on which we meet and across which the Scenic Rim Council area is formed, and pay respects to their elders past, present and emerging, and again congratulate them on their continued nurture of culture. Councillors, I note full attendance of councillors, full attendance of the executive, and I welcome Mr David Keenan as our new CEO to his first meeting of council. And in so doing, I'd also pause and say a big thank you to Carolyn McMahon, GM People and Strategy, for her industrious service as acting CEO whilst we were going through the recruitment process. Thank you very much for that support to the operations of council. And David, we wish you well as we start on another stage of the journey. I believe that leaves us with no apologies, and therefore I come to item 4 on today's agenda, which is the offering of prayers. And I believe we have Pastor Dennis Lumley with us via the phone. Good morning, Dennis. Thank you for joining us. Good morning.
Hello?
Yep.
Yes, good morning.
We're in your hands, Dennis.
Okay. First of all, let me thank everybody for their service to this wonderful area. And now, if you wouldn't mind, just close your eyes, bowing your heads just for a moment. Father, we give you praise and glory. We thank you for this wonderful place. We thank you for all the benefits you've added to us, the richness of this land, the people in this land. I thank you, Lord, for the genius, the intellect, the dreamers, the visionaries. I thank you for those who make these things a reality. I thank you, Lord, for the great potential for our future. And so in that, I pray for these body of people who've committed themselves to this cause. And I pray that your Holy Spirit will help them, lead them and guide them. Even if they don't know you, I pray your Spirit would come upon them, that they might together make the best decisions for the future of this land, that you would lead them with a sense of justice, a sense of fairness, a sense of mercy, but Lord, with a great passion to get the best out of this land and make the best of this land for the people of this land. Lord, help them come together and make really good decisions. Help them put together plans and strategies. And in this, I pray that you would lead them, Lord, through the unity, through the dreams and visions, through the desires for this land, that the outcome might be rich and beneficial and prosperous for the whole land and for the people of the land. So be with them, protect them, their families. Lord, protect their marriages, I pray. We know this can be a very hazardous occupation, but I pray that you protect them and keep them safe, and at the same time help them to be gentle and sensitive, but bold and courageous as well. So Lord, go before them, make the way for them, and lead them in that way, I pray, in Jesus' wonderful name. Amen.
Thank you, Dennis. It's always a privilege to have you share with us. Thank you for the work you continue to do in community, and we understand that you will have a busy schedule. You're welcome to continue to join us through the digital gallery today, but we also understand that you have other work to attend to in your leadership role in community. But we thank you once again.
Thank you very much. Have a great day. Bye.
Thank you. Councillors, we now come to item 5, which is declarations of prescribed or declarable conflict of interest by members. Councillor Swamborough, you've advised, please.
Yes, thank you, Mr Mayor. Mr Mayor, I want to declare that I believe that you may have a potential conflict of interest, which I am required by legislation to notify this meeting of. My belief. And further, I also declare that I have this is in relation to item 10.1, And also in relation to 10.1, I also declare the same conflict of interest and request that the meeting consider the matter and advise whether I can stay in the meeting until the vote is taken.
So, Councillor, thanks for those notifications. Both of them are inadequate at the moment, so we'll need more detail, but we'll pause for a moment before we progress to that. And any other declarations around the table, councillors? If not, now that there's been a matter of potential conflict of interest concerning myself, I will raise 3 additional potential conflicts of interest in relation to considering that matter. In accordance with Section 150EW of the Local Government Act 2009, I am advising the meeting of my reasonable suspicion that Councillor McConnell has a declarable conflict of interest in considering a potential conflict of interest pertaining to myself regarding agenda item 10.1 of today's agenda. I hold this belief based on the evidence of the prior public comments of the councillor on multiple occasions, including within ordinary meetings, which I reasonably believe shows that he holds a predetermined negative perspective when considering my potential conflict of interest matters in relation to the business of council. He has on multiple occasions made comments on public record that a reasonable person might conclude demonstrate he allows his preconceived perspectives towards me in such matters to overrule his legislative obligation to consider the relevant facts for conflict of interest provisions for specific matters. This has continued to occur even after all councillors were provided additional advice from the Department of State Development, Infrastructure, Local Government and Planning of the importance of considering the facts in the context of the specifics of the matter under consideration. I believe a reasonable person fully aware of the facts may conclude he has demonstrated he is unable to fairly consider facts objectively in such determinations concerning myself or my interests due to his preconceived perspective. I also believe a reasonable person may consider this as depriving me of my democratic right in accordance with legislated opportunity to participate as an elected member of council. I do not believe this is properly and fairly serving the public interest. Further declaration, councillors. In accordance with Section 150EW of the Local Government Act 2009, I'm advising the meeting of my reasonable suspicion that Councillor Chalk has a declarable conflict of interest in considering a potential conflict of interest pertaining to myself regarding agenda item 10.1 of today's agenda. I hold this belief based on the evidence of the prior public comments of the councillor on multiple occasions, including within ordinary meetings, which I reasonably believe shows that he holds a predetermined negative perspective when considering my potential conflict of interest matters in relation to the business of council. He has on multiple occasions made comments on public record that a reasonable person might conclude demonstrate he allows his preconceived perspective towards me in such matters to overrule his legislative obligation to consider the relevant facts for conflict of interest provisions for specific matters. This has continued to occur even after all councillors were provided additional advice from the Department of State Development, Infrastructure, Local Government and Planning, recognising the importance of considering the facts in the context of the specific matter under consideration. I believe a reasonable person fully aware of the facts...
Point of order, Mr Mayor.
Sorry, councillor, please. I'm declaring reasonable suspicion. Yes, what's your point of order?
My point of order, Mr Mayor, is that I declared a conflict of interest against you first of all, and then against myself, and then you've proceeded to also notify others of your conflict of interest, which has the potential to influence this particular motion, which I have declared you have a conflict of interest in. The correct procedure in these circumstances is that the first conflict of interest that I raised should have been dealt with by you before you proceeded to go in and deal with the third one that was raised, yours, in this particular meeting. So it's a matter of why have you chosen to deal with yours first and not the one that was raised first?
Councillor, you're incorrect. All declarations have to be visible so you can ascertain who can properly consider the participation. So you're not properly interpreting standing orders. I'm happy to seek advice from the CEO, but I'm quite clear because that's the advice we had from the training with the department when they were here at the beginning of the year, and I'm quite confident the declarations that I'm making, Councillor, are because you have proposed a new matter, which is a conflict pertaining to me, then that creates a new matter, and I'm identifying conflicts in considering that new matter. That has to be properly considered by the meeting before that matter can be addressed. It's just about the proper protocol, but CEO, yourself or the officers?
Through Mr. Mayor, I will go to the officer.
Thank you, Mr. Mayor. I think if we go back to our consistent process that followed some legal advice some time back with these, is that the conflicts are all raised at this particular point, and then decisions made based on what councillors are not conflicted or not suspected of being conflicted to determine those conflict matters. This is following the process that we've previously adopted following legal advice, is my understanding.
So, thank you, Councillor. Can I please proceed?
Mr. Mayor, when I raised my conflict of interest, I was not allowed to explain the conflict of interest, but you are explaining your conflict of interest. Why was that? Why was I not afforded the opportunity of explaining my conflict of interest before you launched into explaining your own, which was the third one raised?
Councillor, all I am doing is fulfilling the proper structured obligation to declare. That is all I am doing. You made your declaration and stopped, and I've flagged to you that the form of declaration you've made for either yourself or myself is inadequate as it stands at the moment. So that will need to be addressed at a point in the meeting. I'm fulfilling the proper structured requirement as far as I understand and have had the advice and the training, same as you have, to do so.
The proper procedure, well, you should have invited me to say why I declared. I was waiting for the invitation to speak, which is what the chair's responsibility is, and you haven't afforded me that opportunity to speak on your conflict of interest.
But, Councillor, there is a reasonable prospect that I won't be chairing when you table that. That's why I haven't given you the opportunity to speak yet, because the prospect is I won't be the chair for it, so someone else should be properly taking that full declaration.
And that should have occurred immediately. It was raised.
That's not correct, Councillor. As has been explained, we need visibility of all potential conflicts to determine who can then properly consider them. You've had that explanation. That is our protocol. It's what we've been advised by both the department and the lawyers on multiple occasions.
I disagree with your interpretation, Mr. Mayor.
I
The fact of the matter was that when mine was dealt with, you could have resumed the chair and continued with your declarations. So that's what I'm saying.
Councillor, I understand, but to be able to deal with mine, so I'll try to help you to deal with mine, there are other declarations that arise because that's a new matter on the agenda. It wasn't on the agenda beforehand, nor was your declaration concerning yourself. Correct? They weren't visible until the start of the meeting. They're now agenda items. They're now matters before the council. I'm trying to deal with them through proper process, and I note you don't agree with proper process, but I'm very confident that this is what... Councillor, please don't interrupt me.
Point of order, Mr. Mayor.
Yes?
I won't sit in this particular meeting and have you make assertions that I don't agree with proper process. I'd like you to withdraw that comment.
I'm happy to withdraw it and clarify, Councillor. I am fulfilling the proper process that we have been advised, both through training by the department and confirmed by legal advice. I just ask that you respect that rather than continuing to dispute it. Okay? Now, sorry, I'll have to return to the commencement of this declaration. In accordance with Section 150EW of the Local Government Act 2009, I'm advising the meeting of my reasonable suspicion that Councillor Chalk has a declarable conflict of interest in considering a potential conflict of interest pertaining to myself regarding agenda item 10.1 of today's agenda. I hold this belief based on the evidence of the prior public comments of the councillor on multiple occasions, including within ordinary meetings, which I reasonably believe shows that he holds a predetermined negative perspective when considering my potential conflicts of interest matters in relation to the business of council. He has on multiple occasions made comments on public record that a reasonable person might conclude demonstrate he allows his preconceived perspectives towards me in such matters to overrule his legislative obligation to consider the relevant facts for conflict of interest provisions for specific matters. This has continued to occur even after all councillors were provided additional advice from the Department of State Development, Infrastructure, Local Government and Planning, recognising the importance of considering the facts in the context of the specific matter under consideration. I believe a reasonable person fully aware of the facts may conclude he has demonstrated he is unable to fairly consider facts objectively in such determinations concerning myself or my interests due to his preconceived perspective. I also believe a reasonable person may consider this as depriving me of my democratic right in accordance with legislated opportunity to participate as an elected member of council. I do not believe this is properly and fairly serving the public interest. Councillors, I do have a third declaration as a result of that new matter. In accordance with section 150EW of the Local Government Act 2009, I'm advising the meeting of my reasonable suspicion that Councillor McInnes has a declarable conflict of interest in considering a potential conflict of interest pertaining to myself regarding agenda item 10.1 of today's agenda. I hold this belief based on the evidence of the prior public comments of the councillor on multiple occasions, including within ordinary meetings, which I reasonably believe shows that he holds a predetermined negative perspective when considering my potential conflict of interest matters in relation to the business of council. He has on multiple occasions made comments on public record that a reasonable person might conclude demonstrate he allows his preconceived perspective towards me in such matters to overrule his legislative obligation to consider the relevant facts for conflict of interest provisions for specific matters. This has continued to occur even after all councillors were provided additional advice from the Department of State Development, Infrastructure, Local Government and Planning, recognising the importance of considering the facts in the context of the specific matter under consideration. I believe a reasonable person fully aware of the facts may conclude he has demonstrated he is unable to fairly consider facts objectively in such determinations concerning myself or my interest due to his preconceived perspective. I also believe a reasonable person may consider this is depriving me of my democratic right in accordance with legislated opportunity to participate as an elected member of council. I do not believe this is properly and fairly serving the public interest. Are there any other declarations for today's meeting, councillors? We have 5 declarations. 3 relate to the potential conflict of interest that Councillor Swanborough has notified for myself, and the others pertain to myself and Councillor Swanborough. So, councillors, that leaves 2 non-conflicted councillors to consider conflicts of interest at this time, and need you guys, I guess, to decide who should chair such a conversation.
I'm happy for Councillor Enright to chair this.
Thank you, Councillor West. Okay, so I might just establish some of the ground rules. As Councillor Swanborough has declared his conflict of interest in 10.1, he won't be able to participate or influence the decisions. We will address these individually, so we'll go through Councillor McConnell, Councillor Chalk, Councillor McGuinness in determining whether... I'm sorry, Mr Chair, point of order. Yes. My declaration was a potential. It wasn't a declaration that I had a conflict of interest. It was a potential conflict of interest, and I asked the meeting to decide. Yeah, thank you, Councillor Swanborough. You are the subject councillor to the item, so I think you have an automatic conflict of interest.
Point of order, Councillor Knight. You may seek guidance.
Yes, happy to seek guidance.
I guess, through your chair, the reference from the correspondence, and just to highlight about the notice of motion pertains to an inappropriate conduct matter with the subject councillor being Councillor Swanborough. I guess previous advice has been that you're deemed to have a conflict of interest, and that in the first instance you should make declarations. But having being deemed as having a conflict of interest is and then seeking, it would be at odds to seek counsel then to make a ruling on whether the conflicts exist. The advice is you're deemed, as a subject counsellor of the matter, you're deemed to have a conflict of interest in that matter.
We are not considering that matter at the moment, sorry, but we are considering a COI, and I have a right under legislation to have my COI deemed by the council as to whether it exists or not. This is not about the matter on the agenda. It is about a COI. I have declared a COI against the Mayor, and I've declared one against myself, and both need to be treated in the same way.
Sorry, through your chair, just for clarity, I was referring to the second declaration about the Councillor Swanborough's potential conflict of interest in the matter. I know we're dealing with the conflict of interest, but the conflict of interest is in relation to the matter, if that's of...
Chair, may I just see, because that does sound a little confused, but is it it's worth clarifying, because it's important for those listening to understand that once a potential's been declared, you're deemed to be conflicted for the consideration of that until such time as it's resolved. Is that what you're trying to explain, Chair, through you? That might be helpful.
Yes, I'll happily ask the General Manager of Council Sustainability to respond.
Yes, that is correct, and I guess I'm always just trying to align back to correspondence received by all councillors in that particular matter, and the consideration to that identifies the due process.
Thank you for that clarification. We'll proceed. So we will address each potential suspected declaration of interest, and the opportunity for each of the councillors to respond, and if the Mayor needs to provide any additional information, he will be given that opportunity. We will then make a decision and then address the orders that may be appropriate on the individual declarations. So I'll commence with Councillor McConnell.
Acting Chair,
Yes, certainly.
could I just ask, given our recent correspondence from the department, could governance give us a view on, this is not dissimilar to what they ruled on, what they've given an opinion on from the meeting of the 8th of December. Does governance have a view on that? Or management of any kind?
Through you, Chair, I guess this is my view, and I guess we to get clarity may need to seek further advice. But obviously, the advice that was sought from the department related to a particular matter or particular process, and it's hard to me or anyone within the governance team to directly apply that to the same matter today, or different matter that's today. It's not exactly the same. I guess, without going into the details of that correspondence, that related to different elements of what the suspicion was.
Could the General Manager please explain why it is not similar?
I'll try and paraphrase. I guess the advice was in the previous raising of under 150 EW, the suspicion was around media articles and everything else that pertained to the potential influencing, and that was that particular. Today's declaration is on different elements, and I'm not the one to, obviously any considerations of conflicts are decided up to the councillors. The Minister was sought to particular advice on that particular matter, which had those elements, and this is partly different to what that was today. So, as again, that's my view on that word. So.
Okay, we'll proceed. Councillor McConnell, would you like to respond, please?
If I could just have the Mayor's conflict back up on the screen. Sorry, I will. I just need the Mayor's conflict back up on the screen so I can address it.
On point of order, Mr Chair, are we just going to deal with Councillor Swanborough's conflict first of all?
No. No. We'll deal with that afterwards.
A couple of issues here, being that I've been consistent throughout the whole thing. I have, as he states, I've publicly said that I believe that Councillor Christensen and Councillor Swanborough both have a dislike, an obvious dislike, that is out in the public against each other. I don't believe that the reasonable person out there would allow someone with such a dislike to rule against another person, and it definitely wouldn't be allowed in our court system. I also note there that he makes reference that, just need to go down, that we have failed to adhere to provided advice from the state development infrastructure local government, which is a bit concerning. I'd also like to state that on the 11th of October, when this matter first came, 11.2, 11.3 and 11.4 to Council, he made no conflict of interest against myself or the other two councillors, and accepted the fact that he had a conflict of interest for that matter. We're still dealing with this matter. So I can't understand where the Mayor is coming from in regards to now wanting to be involved in something that we're always said when someone thinks there's a conflict that we should always just step out. So, you know, I can see this going the same way as it went last time, that I have a conflict against the Mayor, but the Mayor won't have a conflict against Councillor Swanborough. So I'm really at a loss to why the Mayor really believes that by hell or high water he should be involved in this when we believe he's got a conflict, and most people out in the public. So it's going to be up to the two unaffected councillors to decide again, and we'll see where that takes us.
Point of order, Chair. I've been very patient, but it's disappointing. I believe the council has turned this into...
Point of orders can only be raised on 3 occasions. Point of orders, if we have a look at our standing orders, points of order can only be raised when it failed to comply with proper procedures in convention with standing orders and beyond the jurisdiction and power of council. Just because the Mayor does not agree with what I said does not allow him to call a point of order. It states that up in 20.6, points of order cannot be used as a means of contradicting a statement made by the councillor speaking.
Thank you, Councillor McConnell. I understand that. Let's can we determine what the point of order is that the Mayor is raising.
I appreciate, in fact, I will, if I may, add additional information. Councillor McConnell has opened a number of things. Firstly, can we deal with the matter on the 11th of October, which he pins on? At no time did I accept that I had a conflict of interest, but seeing as he's made comments that allege things, I believe it's reasonable for me in responding to that councillor to put in clarity. The basis of the alleged conflict for me on the 11th of October was the comments by Councillor Swanborough. That was the only basis of evidence that was provided. Those matters have been referred to the OIA, and in fact I was referred to the OIA following that, and I have a correspondence from the OIA that, without reading it in full, it both references to a piece of documentation, but it actually identifies that the basis of that alleged conflict of interest on the day were not considered to be factual, or things which would not be within Councillor Swanborough's knowledge, which was the basis of that conflict. The councillor is right. I didn't challenge on that day because I believed, on good faith, providing the evidence of the day, which is a record of council, that all of the allegations were either spurious or were challenges because I have fulfilled my legislated obligation. If I come back to the basis of why I believe Councillor McConnell has the conflict of interest, as he indicates, he has multiple times confirmed he thinks both I and Councillor Swanborough are biased or negative towards each other. I don't believe the only basis for that is the way I chair and manage the meeting, it seems, because I don't make comments in public concerning the councillor. That's part one, but it also goes to the fact that the evidence on the table showed that there was no basis to the alleged conflict, and that evidence wasn't heard or considered, and the statements made on that day simply went straight to, we believe you, I believe you and Councillor Swanborough are both biased against each other. The councillor also went on to comment that he would apply that same perspective if I was the subject councillor of a matter regarding the participation of Councillor Swanborough in such a matter. However, the records of council show that in fact this has not been the standard he has consistently applied. And for one example, I refer to the meeting of the 5th of October 21, where there was consideration of a potential conflict of interest for myself with receiving a publicly available report regarding the Water for Worrell project. On that occasion, not only was Councillor McConnell willing to have Councillor Swanborough involved in the consideration of my potential conflict, he also allowed Councillor Swanborough to introduce additional perspectives of conflict of interest towards myself after I had left the meeting room, to which I was denied the natural justice opportunity to respond. These deliberations ultimately led to a finding of a conflict of interest against me that limited my ability to properly fulfil my role. So that's the additional information to those 2 points that I raised, and I agree with the councillor. I didn't challenge because as I was asked last meeting, I have on multiple occasions tried to allow good faith for the guidance of the department to hold sway, and on each occasion that has left me in a position where a baseless finding is upheld.
Can I respond?
You can, you may.
The Mayor's erred in what he said in my being consistent, because I've been consistently saying items of discipline or conduct, not items of conflict of interest. I've always said if there's an item of discipline or conduct between either of the two councillors, then I would make sure, I would be of the opinion that the other one should not be hearing it. So the Mayor's brought up that I haven't been consistent, and that is incorrect. So I've been dealing with, and I've said from the start, anything dealing with conduct, then I would move against both of them.
Councillor West, do you have any further any questions?
Before I go on,
yes, sir.
We're going to need that letter tabled that the Mayor brought out into the open, into the public. So the Mayor brought a letter from the department and read part of it out. Can that be tabled?
Point of order, councillor.
I'm just asking.
It's a personal letter from the Office of the Independent Assessor that was a referral. I am happy, subject to guidance from governance about any redactions that should be made to protect any other parties that were referenced in that. I'm happy to disclose this personal communication.
Thank you.
Thank you, Mayor. Thank you, Councillor McConnell. Councillor West, do you have any further questions or clarifications?
No, I don't.
So you're happy? You've provided your responses? Yes, that's the system. That's the progress. Okay. All right then.
Chair,
yes.
sorry, could I just ask a question to the CEO or to the General Manager? Given all of this and the fact that we have an assessor coming to sit in our meetings, an advisor, would it be prudent to put this item off until that time, till next year, when we have proper guidance in the room?
Through Mr Mayor, I would be not relying on the governance advisor at this point. That person hasn't been properly procured at this point in time, so no, I would not.
Thank you.
Happy with that clarification, Councillor West?
Yes.
Okay then, all right. So we'll move to determining Councillor McConnell's declarable conflict of interest. So one of us have to move that, and if you're happy, I'll move that Councillor McConnell has a declarable conflict of interest in determining the Mayor's conflict of interest relating to item 10.1 of today's agenda.
I'm happy to second that in this situation. Yes.
All right, thank you. Any further clarification? Okay. Put that to the vote. In favour? Carried unanimously. So we now move to Councillor Chalk. We'll do that at the...
You should do it.
Should do it
You I believe the proper process, Councillor, if I may assist, is you should do it now.
Right, okay, all right, okay then. Just looking for some wording. I am just looking for some wording. The wording, I think, would be that that Councillor McConnell...
I wonder if you could speak up, please,
Certainly.
Mr. Acting Chair, because I just cannot hear what you're saying.
Thank you, Councillor Swanborough. I'll certainly try it. So that I will move that Councillor McConnell will be allowed to remain in the room but not entitled to vote on the matter. All right?
Through you, Chair, just seeking some clarity at the moment, the way it's written.
Right, okay.
What the point of the matter we're at the moment is determining the Mayor's conflict, not the matter.
Okay, yes, correct.
If
So
that's
better change that to...
the Mayor's conflict, yeah, so just to clarify, not the 10.1.
Correct. So, but not be entitled to vote on the declaration of Councillor Christensen.
I think, Councillor, it's the potential conflict of interest.
Of the potential, okay. Potential.
Just seek the guidance from governance, but I think that's probably the...
Mr. Mayor, likewise, your comments I cannot hear. If you could speak into the microphone, please.
Yeah, probably some suggestions, and
Yes.
certainly can apply the word is that to the extent that Councillor McConnell will not be allowed to remain in the room, but will be allowed to remain in the room, but not participate to vote on the potential consideration of Councillor Christensen's conflict of interest. If that's simpler.
On the consideration of Councillor Christensen's conflict of interest.
Was that your intent, Chair?
Just checking the wording. Thank you, gentlemen. Yes, I think that's. Yeah. Thank you for that wording. Councillor West, happy to second that?
Yes, as I've said, I'm happy to second.
Okay, thank you. We'll put that to the vote. Those in favour? Carried unanimously.
Now that's done, could I just ask a question of governance? In the motion that I do have a conflict, does it need to state in there what my conflict is? In the motion?
I think so.
Do the unaffected councillors need to identify what my conflict is in the motion, or it's just, yes, he has a conflict? I'm just asking a question. It's just a question. It's purely because the unaffected councillors haven't given me what my conflict is. The mayor's raised some suspicions, but I haven't been told what my conflict is.
I guess from a procedural sense, the disclosure by the mayor in the suspicion of his conflict against yourself has been accepted and moved on with the non-conflicted councillors in determining. So I guess in the sequence of that meeting, the statement by the mayor has been accepted by the non-conflicted parties in determining that conflict, and that's rather than trying to regurgitate that in there, it's in that sequence.
Okay, thank you.
Thank you for that clarification. We'll now move to Councillor Chalk. Councillor Chalk, would you like to respond?
Yes, in the words that the Mayor read out, he said that there was a predetermined negative perspective that I had, and the evidenced by public comments that I've made, probably is a good time to actually share those public comments that I've made that has a predetermined negative perspective on the Mayor. So if you could provide them for me, please.
Thank you, Mayor.
Thank you.
Provide that.
Happily to, and I haven't got the verbatim words, but on multiple occasions in this chamber, Councillor, on the recording, you've echoed words that you refer to both myself and Councillor Swanborough being biased against each other or having a negative perspective to each other. I believe you've used the terms biased against each other as being the common thread, and that's happened on multiple occasions over time, and I refer also to the prior occasions that I've previously referenced without going there, which have demonstrated that you've also said, as recently as the last discussion of, I think, the 11th of October, that you considered that if the roles were reversed, not specific to discipline matters, but just if the roles were reversed, was the limited comment, that you would apply the same limitation for Councillor Swanborough. And I refer again to the evidence of the 5th of October 2021, where that actually wasn't the standard applied in the consideration of my conflict of interest on that occasion.
Councillor Chalk, would you choose to respond?
Yeah, I think it draws a long bow to take something back in 21 and bring it forward to a consideration right now. Things move on and we change our perspective. It's interesting, we sit in the room here and we form opinions about things, about all sorts of things, and we're asked to make the determination which we think is in the best interest of the community, and that's always what I've done in these situations. I believe that it would negatively affect the public's trust in us if we did allow it, and that's why I've been considering this in that light, by making a comment in their moments, I don't believe is a really great form of evidence that I am biased and I can't objectively look at something. So, look, I leave it to the two councillors. They got to look inside themselves and think that if this is really the decision they should make, and I leave it to them, and they can choose the decision they make, and we'll just sit here and live with it, I guess. So.
Thank you, Councillor Chalk. Councillor Christensen, any further response?
Look, I guess the piece of evidence, it's been very emphatically...
Do we need to rebuttal? I don't understand how... I didn't ask for a rebuttal. I gave a comment, and then I left it up to the councillors to decide. I don't need a rebuttal from the mayor. Otherwise, then I'll have to rebut him. So,
happy for you to...
Chair?
Happy for you to...
Sorry, Councillor, I thought...
I didn't need my comments rebutted. That's my whole point here. I made a comment. I don't need them verified, facts checked by anybody. So be real clear about what you're doing here, Chair.
Yep, Councillor Chalk. I'm happy for as much discussion as necessary from both parties to assist in determining our decision.
I think...
Mr. Mayor, point of order, Mr. Chair. Does that also mean that I can discuss this as well, if you want as much discussion as possible?
No, it's already been
determined,
Councillor Swanborough, that you are the subject councillor and aren't able to participate. Thank you.
Look, Mr. Mayor,
point of order, Councillor
Point of
Swanborough.
order from me first, Mr. Acting Chair. There is nothing in legislation that says that anybody in this room, nor the Department of Local Government's opinions to governance or whatever, can determine whether I have a conflict of interest or not. Now, I completely reject the notion that my conflict of interest has already been determined. I have declared a potential conflict of interest, and I have a right for that potential conflict of interest to be determined by council. Unless you can show me in legislation where it says that somebody else can determine whether I have a COI, I'm sticking to the point and believe that I have every right until that's decided to participate in the meeting on this particular matter.
Thank you, Councillor Swanborough. Unfortunately, you seem to have selective hearing regarding the advice that's been given, and it's already been determined that you are the subject councillor and you are not to participate in influencing the outcome of this discussion in determining the Mayor's conflict.
That is not what the legislation says, Mr. Mayor.
I'm sorry, that's the advice that we have received through governance, and that's what we have consistently used. So, thank you, Councillor
I have to
Swanborough.
seriously challenge that advice because
I
the
understand that
Local
you have a
Government
different
Act
opinion.
says
However,
that is not the case. It says that only the councillors can determine a COI if it is declared as a potential COI. No one else can make that decision.
Councillor, and thank you. So, Mayor, I will...
Thank you.
Back to you.
Look, I'm not trying to rebut. I think a statement that predetermines that two councillors are biased against each other, and I'll respond to whatever comes up later, but if I refer to the evidence of the 11th of October, I pointed out there that the basis that was alleged for conflict of interest was based on my proper fulfilment of my role as chair, and I haven't had anybody provide evidence that I've acted outside of that. This conversation that everybody thinks that's the basis, I've not made any public comments outside of the proper discharge within the chamber or the proper discharge within processes that we're required to abide by. And that's where the statement that both I and Councillor Swanborough are biased against each other, my concern is that demonstrates a predetermined outcome regardless of what evidence for the matter of the day. That was all I was clarifying was the basis of my declaration.
Councillor Chalk.
Yeah, that's interesting because I don't think I've ever said that fulfilling your legislative duty is a reason for the bias, and you've just provided evidence that you think that it is. You're entitled to that opinion, but that certainly has never come into my thinking. all I've really ever said about this is whether a reasonable or fair-minded person in the community would lose trust in the decision being made if you were to participate, and I've got overwhelming evidence of that. I could go talk to anybody, and I do talk to nearly everybody, and they all believe that. So, that's how I determined what my feelings are on this matter, and I'll stand behind them every day of the week. Certainly won't, back down from them. I believe what I believe, and by saying so doesn't make me conflicted. So, once again, I'll leave it to the two councillors to really look inside themselves and see what they're going to do here. So.
Councillor West, do you have any further questions or clarifications?
No, and I've listened to what Councillor Chalk has said. I don't actually like the comments to look inside myself, to be honest, but I don't have any other questions at this stage.
Okay. Well, we'll proceed to the determining the matter, and I will move that Councillor Chalk has a declarable conflict of interest in determining the Mayor's conflict of interest in item 10.1. If I could just have those words from the previous motion to make sure that's consistent. And Sharon, if I could just check that that is consistent with the previous one.
Just change the names, Councillor.
Just to, yeah, okay, thank you. Okay, thank you for that, Councillor West. Happy to second that.
Well, I'm happy to second it for discussion purposes only, actually.
Thank you. Further discussion?
Yes, I just want to say, look, and I've certainly listened to what Councillor Chalk has said, and I don't recall there being any discussion outside of the council about the bias. So I do actually feel that Councillor Chalk doesn't have a conflict of interest in this morning.
Okay.
So I'll be voting against them.
Okay then, that's, thank you. So we'll put it to the vote. Those in favour of the motion? Those against? The motion is equal. I will just check with governance on the process regarding that now.
Yeah, thank you, Chair. I don't have the section in front of me, but from my recollection is if there's not a determination made that the subject councillor does have the council does have a conflict of interest, it's deemed that he indeed does have a conflict of interest. So if you can't reach a majority decision or a consensus on the conflict, then he's deemed to be conflicted. But I can...
Question,
Yes,
Acting Chair.
yes.
Doesn't a casting vote come into this, no matter who's chairing the meeting with whatever amount?
I'll check with governance on that. I'm happy for the...
I always thought, but maybe this is different on a COI.
Yeah, that through you, Chair, that is correct. There is no casting vote on the COI, and you don't need. And similarly, in determining COIs, you don't need a quorum as well, and that's why that particular provisions in a clear determination of not finding a conflict. If it's a split vote, then it's deemed to have necessary weighting that there could exist a conflict.
So just clarification from the General Manager then, or governance, that if there isn't an outcome, it is deemed that there is a conflict, so we then still need to work through the process of the orders.
Yes, through you, Chair. If I just read 9.10 if the non-conflict of our standing orders, if the non-conflicted councillors cannot decide about the declarable conflict of interest of a councillor, they are taken to have decided that a councillor must leave and stay away from the meeting while the non-conflicted councillors discuss and vote on the matter. So that's the interpretation is that with the non-conflicted councillors deciding on the matter, if it's a similar vote, 1-1, then it's not as the previous advice indicated, that there's no clear indication that there isn't a conflict. Then it's taken to have been that there is a conflict in existence.
Sharon, could I just have the orders shown on the previous item, please? I will now move that Councillor Chalk be allowed to remain in the room but not participate in the vote on the consideration of Councillor Christensen's conflict of interest.
Wait a second.
Any further discussion required, Councillor West?
No, I'm happy to second.
Okay. Put that vote. Those in favour? Carried unanimously. We'll now move to the third declaration. And ask if Councillor McGuinness would like to respond.
Yes, Acting Chair, thank you. I will speak. A similar process at the last meeting. I thought it was a waste of time, and it probably is, but I respect the two councillors, the non-conflicted councillors, and I'm sure they will look seriously at this. I just mention it's interesting that Councillor Christensen mentions the Water for Worrell project. In actual fact, and I can't give an exact date of the meeting, when I was Deputy Mayor, I actually used my casting vote, and he did raise a possible conflict of interest, and I used my casting vote to actually allow him in, which suggests from governance it shouldn't have been allowed in hindsight, but we've learnt a lot of things over the time. But if I was that biased against him, I wouldn't have voted in that way, and I sometimes vote with the Mayor and I sometimes don't vote with the Mayor, so I like to think that I judge every subject on its merits and the way I see it and in the best interest of the community.
Councillor Christensen, would you care to respond?
Look, one of the comments that I refer to in shorthand, this actually is straight out of the minutes from Councillor McInnes. It's my belief the Mayor has a conflict here, and if the roles were reversed, I'd be saying the same thing about Councillor Swamborough in this. As I say, if the roles were reversed, I think there is very hard not to have a bias given how they behave towards one another. None of that was evidence on the table. None of that was presented at the time. This was simply a comment that when that comment was made, there was no right of reply, and there was no evidence given of what that looks like, beyond the evidence that Councillor Swamborough had put on the table, which has subsequently had that finding from the IA. So I believe that comment clearly is a repeat from a prior occasion, and it demonstrates that at this point in time, certainly there is a preconceived notion that can't consider the facts of the day, remembering that in considering conflicts of interest, we're supposed to look at the matter before us, the evidence of potential conflict, and whether there is evidence of a conflict with the matter that's there, rather than, and the the advice from the department is so-called whether people like or don't like each other isn't a reasonable basis for determining a conflict of interest. It's the materiality of their ability to participate objectively.
Mr.
That's
Mayor,
my comment.
in reply to that, the
Sorry,
OIA
Mark.
evidence.
Point of order.
Look,
I'm sorry, Councillor Swanborough.
I'm happy to.
Point of order.
I'm happy
Point of
to
order,
for the
Chair.
Point of
you are
order.
the chairman, Mr. Mayor.
I'm the chair.
I'm raising a point of order here first, Mr. Acting Chair.
And I'm raising
The
a
fact
point
of
of order in determining
Right,
that
tell me
you
what it
don't
is.
have, has been determined that you cannot influence this discussion because you are the subject councillor. So I thank you for your
I'd like to
abundance
raise
to that.
I'd like to raise a notice of dissent on your ruling, based on it is not in accordance with legislation.
I will seek guidance from governance regarding whether that's a valid point of order.
While we're waiting for that, I'd like to make comment that in the managing conflicts of interest spreadsheet that we have from the department, one of the things, have a declarable conflict of interest, interests where a reasonable person might think you could be biased.
Point of order.
Is exactly what we've been saying.
Yes.
Point of order.
We are seeking response to that. But let's just
Point of order.
add some.
Point of order, Chair. Councillor McConnell has been found to be conflicted and is now trying to influence deliberations in this matter.
So, thank you. We'll just stay with us, Councillor McConnell. We will seek the response to Councillor Swanborough's point of order, and then we'll respond.
It's not a point of order, Mr. Deputy, Mr. Acting Chair. It is a motion of dissolution that we're dealing with.
Disillusion. Right. That's interesting.
Dissent, I should say. let's dissolve it as well.
Through you, Chair. Yes, through you, Chair. Just with all the we've lost track of where we are, but in trying to determine that a point in time, I believe a point of order was raised against Councillor Swanborough in providing, and then Councillor Swanborough then raised a motion of dissent. Is that pretty much
That's
where we
correct.
are? Okay. So in determining where we
Based, to say the whole story,
Thank you,
Mr. Jihim,
Can you just
based on
hold
the fact that
until
it
we
is
get the
contrary to
response?
legislation.
in raising a motion of dissent, which part of the standing orders of legislation is?
Well, the legislation clearly says that the only time someone else, other than this council, can determine a conflict of interest is if it's a prescribed conflict of interest. And the Act sets out what a prescribed conflict of interest is. The other, what I have declared, is a potential conflict of interest, a declarable. So I have actually done what the law says, and I have declared it to this meeting, asking for them to decide, not on the voices, not on the governance's opinion or anybody else's, but on the vote of this council as to whether or not I have a declared conflict of interest. Now, if you can point to somewhere in legislation that says that that is not the correct view of doing this, I'll be all interested and I'll abide by a decision if it's based on the legislation.
So again, we're just trying to determine which ruling are you raising the motion of dissent against? Which particular ruling, sorry?
The motion of dissent was that the acting chair said that I could not speak on this matter because it's been determined that I have a conflict of interest. And I'm saying that I do not at this point in time have a conflict of interest because it has not been determined by resolution of this council in accordance with legislation.
I'd just like to correct you on the wording. I said that you are the subject councillor. That is very much a different matter than.
Well, it's not a prescribed conflicts of interest being a subject councillor unless someone can tell me under the prescription that it is.
It is. It is. It is a bit.
Sorry, just to go out of sequence, can we address that concern and make reference to where it's contained in the standing orders about being a subject councillor, if that's going to help?
I'm talking about the legislation.
The standing orders are part of obviously the model standing orders, which are produced by the Queensland Government, which are incorporated into council standing orders. They're part and parcel with the legislation, so I'm happy to provide that for clarity, and so that council, or just make a reference to a page if whatever suits.
Could you also advise in your advice if those standing orders that have been adopted are in accordance with the model standing orders adopted by the state in relation to that piece of legislation?
They have been. Notwithstanding the model standing orders, if there's anything that's amiss from council's adopted ones, because there are some variations which we've gone through the process with, that the model standing orders and the legislation will always trump council's standing orders. So if there's something particular contradictory in our standing orders that offends the model standing orders produced by the Queensland Government or legislation, then as such, the legislation will trump council's.
So in giving this advice, are you talking about the actual standing orders or the council's adopted standing order procedures?
I'm referring to council's adopted standing model procedures, standing orders, which are based predominantly on the model standing orders, albeit some identified and deliberated changes that council incorporated as part of them.
Could you read out the relevant section of the model standing orders in relation to this matter?
Is a debate on the model standing orders or the concern about?
Well, if there's I'm asking this question because if there is an inconsistency between the two, we understand that the model standing orders take precedence. And so that's at the heart of this particular issue.
Okay, whilst I look that up in the model standing orders, I will get the governments to read what's in ours, and I can then, when I find that in the model standing orders, I may be able to provide the same reference.
Yeah, thank you, Chair. I'll just draw your attention to Section 7. It is headed up meeting process for dealing with suspected inappropriate conduct, which has been referred to council by the independent assessor.
So is this the procedures or is this the model?
Please.
This is council's
thank you.
adopted standing order procedures. And it goes down to just before 7.1, the paragraph before says, when dealing with an instance of suspected inappropriate conduct which has been referred to council by the independent assessor, 7.2, the subject councillor has a declarable conflict of interest in the matter and is permitted by council to remain in the meeting during the debate about whether the councillor engaged in inappropriate conduct and to answer questions put to the subject councillor through the chairperson to assist the councillors in making a decision. Now, just to clarify, this is in relation to determining inappropriate conduct matters, and 10.1 on today's agenda is repealing, potentially amending a resolution or an order that was decided by council on that particular matter. So it's not clear here. It doesn't deal with, in that much detail, whether or not this fits the deemed provision of the subject council having a conflict of interest. And the General Manager will just go through what the model standing orders say and you can compare them.
Page 17 of the best practice standing orders for local governments and standing committees published September 2020 by the Queensland Government. It's under subheading 24, which is titled Meeting Process for Dealing with Suspected Inappropriate Conduct, which has been referred to a local government by the independent assessor. In particular, 24.2 of that section, it says, the subject councillor has a declarable conflict of interest in the matter and is permitted by council to remain in the meeting during the debate about whether the councillor engaged in inappropriate conduct and answer questions put to the subject councillor by the chairperson to assist in other councillors in making the decision. This permission to remain in the meeting for the debate is on the condition that the subject councillor must leave the place where the meeting is held, including any area set aside for the public during the vote on whether they have committed inappropriate conduct, and what, if any, penalty to impose if the councillor is found to have committed inappropriate conduct.
Okay, thank you. I'm happy with that. That it's if it's the legislation says that the chief executive can make model standing orders. You've read out the section where I believe that provides clarification. So I'll concede and accept that that is a part of the law in relation to this issue.
Thank you, Councillor Swanborough. Thank you, General Manager.
Through you, Chair, just for meeting process, does that equate to withdrawal of the motion of dissent? Just for clarity, because what we've got on the board.
Yes, that's right. I'll withdraw the motion of dissent.
Okay, so returning to Councillor McGuinness, did you have any further response
Yes, Mayor. Acting Chair, I don't know whether the Councillor Christensen had finished his. I think he got.
Right, sorry.
Yeah,
yes.
yeah.
Happy for the Mayor to.
He actually hasn't, as I raised, though, I actually did use a casting vote, as I said, to actually allow him to stay in the room on that particular instance. So I just question the bias that I might have. But I look at everything on its merits.
Mr. Acting Chairman, I'd like to make another comment.
I'm sorry.
On reflecting about what has been said, I was wrong in withdrawing that notice of dissolution, and I'd like to reinstate it. Motion of dissent, I'd like to reinstate it based on the fact that the model standing orders refers to COI, refers to conduct matters. It does not refer to COI, conflict of interest matters. And therefore, I wish that my notice of dissent remain on the books.
Can I seek clarification from governance regarding that item, please?
Thank you, Chair. I think the governance officer provided a brief intro that whilst the wording relates to a decision around the inappropriate conduct matter, there's a sense of, and I guess there's an uncertainty or there's a sense of unclearness around the application as to the conflict of interest. But the fact that the conflict of the matter itself, the notice of motion, relates to the inappropriate conduct matter, there's a level of assertion that there's an application that seems fit. If it's two separate matters, obviously a conflict of interest matter then would indicate that this only pertains to a inappropriate conduct matter.
If I can decipher that, so because the conflict of interest matter relates to inappropriate conduct matter, then the ruling regarding the subject councillor holds sway on the way of the participation of the subject councillor. Does that sound like a reasonable summary?
Mr. Acting Chair, the matter of conduct has already been decided.
Yes.
This is not a resolution about deciding the matter. This is a resolution about an ancillary, mere referring the matter to the advisor who for a review. And so there's a very grey area in relation to this as to whether this is a conduct matter or a COI matter.
Sorry, Chair, I don't know how much more we can sort of explain. So I guess it's not the decision of any governance officers or officers. It's up to the determining councils. But at the end of the day, I guess from what we can decipher, there is an interrelatedness of the notice of motion which relates to the inappropriate conduct matter, as Councillor Swanborough indicated. It's not for anyone else to determine the conflict, but the presiding. So. Councillor Swanborough correctly states the inappropriate conduct matter has been deemed or determined However, this notice of motion impacts in some way that finding, that decision. So when you think about the conflicts of interest being a particular interest in the matter, you could indicate that that's being the case, the way that the standing orders has indicated and prescribed. So I guess I'm just reiterating. I'm not. In no way that's a position, but that's just the advice.
Happy to let the council determine that matter.
In which case now the motion of dissent is still on the table at the moment, and that's the participations in that is now all of. I'm just trying to.
Who can participate?
We're just trying to work out who can participate in the motion of dissent. If you just. So we do believe that in determining the motion of dissent, it's still left to the unaffected councillors.
And at this particular point, given the arguments put forward, am I an affected councillor or not? I mean, this is what it all comes down to.
I would deem you'd be affected.
Yes.
That's only an opinion based on the standing orders and the way it prescribes.
Okay, so we have let's deal with the motion of dissent. Councillor West and myself are the two non-affected councillors that can address this. So the motion is, where is it? Up there, right, okay, yep. So So, Councillor West, we have.
Sorry, I'd just like
yes.
to see it all in front of me because it's.
Yeah, sure. Right, I'll give you some time. Yes, certainly.
I want to see it properly once it's all written up there, and I appreciate where you're at,
Yes.
Sharon. So if we could just be a little patient.
Councillor Swanbrad, that is effectively a motion of dissent.
Belief. Can't say it's a fact.
Acting Chair, I just have a question, if I may.
Certainly, Councillor
Please,
West.
just to the General Manager, could you just very simply explain to me how it is contrary to the legislation? Because there was quite a bit of talking going on before. I just need some clarification around that.
Sorry, that's not for me. That's not a factual. That's a that's Councillor Swanborough, so I guess he's better suited at that.
Councillor Swanborough, could you just explain that to me?
Yes, look, there are two types of conflicts of interest in legislation. There are those that are prescribed and set down. There are also those that are declarable, which are to be determined by the councillors on a vote. And there is also standing orders, which the Bible on standing orders is the department's own standing orders, which does form part of legislation according to the Act. Now, in this particular case, the department's standing orders, would say that in the determination of a conduct matter, then the councillor should have a declarable conflict of interest, and he should step out of the meeting. And if he doesn't, it could be subject to determination by the LAA. In this particular case, the decision is left open because the conflict, the matter is not about conduct. It is not about whether or not I breached it. It's acknowledged that the council's made a resolution that I did. Done and dusted. The issue here is that we have an advisor being appointed, and the request that has been made by the state government, the request that has been made for the advisor to determine or review or for me to exercise any other review rights I have in relation to that matter. So it is very doubtful whether, that is caught by the department's own standing orders, model standing orders. And that's why I'm saying it's contrary to legislation in this particular instance.
Councillor West, does that satisfy your query?
No, not really.
Okay, right.
Through you, Acting. Councillors need to be very careful about what the role of the governance advisor is going to be. The governance advisor is there to advise. The governance advisor will make recommendations primarily to the department in the first instance, then back to the council in the second instance. They will be around process improvement. It will be about how to deal with conflicts of interest. It will not be about deciding conflicts of interest. So we need to be very clear. That's why the terminology is governance advisor. And again, the first place they will go to provide feedback is the department. So as part of the advisor's process, there will be feedback given on the standing orders. There will be feedback given on conflict of interest and other relevant information. But they will not be, that person will not be a judge and jury as per se.
And if I could make a further, clarification on that matter, I've provided advice to the Chief Executive Officer of a letter that I've written to the Minister and to the head of the Director General of the department, saying that I'm not appealing this decision anymore. I'm asking for just a review of the section. Now, under that section 121 of the Act, the advisor reports to the Director General, who reports to the Minister, and has powers, if they deem that procedures haven't been followed correctly, to do that. And I'm asking the Director General to include in the advisor's role that particular process.
Councillor Swanborough, I feel like this is becoming very much more complicated than what it is really the matter at hand.
Okay, so Councillor West, are you happy to proceed now on determining the notice of dissent? So Councillor Swanborough has moved a motion of dissent that the acting chair said that I could not speak on this matter because it's been determined that I have a conflict of interest, and I'm saying that at this point of time I do not have a conflict of interest. So we've got a mover, so I'll call for speakers for the motion. If not, I'll call for speakers against the motion.
Look, I can't support the motion, I'm afraid, this morning.
And I will speak against the motion as well. I think we need to step back, and it's important to understand that inappropriate conduct matters have been found against Councillor Swanborough, and we've provided avenues through the correct process to enable that to be dealt with appropriately, and I can't support this motion of dissent. So I'll put the motion of dissent to the vote. Those in favour? Those against? The motion is defeated. Now we will progress with, I think Councillor Christian, the Mayor, was responding to items raised by Councillor McGuinness. Thank you, Mayor.
Thank you, Acting Chair. I'm not quite sure where I realised Councillor McGuinness had put a position. I quoted a comment by the councillor, which I believe shows a predetermined consideration. It's my belief that the Mayor does have a conflict here, and if the roles are reversed, I would believe I'd be saying the same thing about Councillor Swanborough in this. As I say, if the roles are reversed, I think there is very hard not to have a bias given how they behave towards one another. I've had multiple allegations that have not been substantiated, and that evidence has been previously demonstrated and discussed with regard to that. So I believe that demonstrates a preconceived outcome that can't consider the facts when they are placed on the table when it comes to potential conflicts of interest for me in these matters. And that's what I'm asking the meeting to consider as my reasonable suspicion.
Councillor West, do you have any further questions or clarification needed?
No, and thank you, Councillor McInnes, for your comments. Do you want a motion?
Yes, you happy to move?
I am. I'm happy to move that Councillor McInnes does. I need to go back to what it was. Can you just go back to how it was a little bit further up the screen, please? No. No. Councillor Chalk. Councillor Chalk. Well, I'd just like to be able to read it out, if I may, please. But I'm looking at my screen. No, it needs to go up a bit, please. Okay. Yes? No?
You need to change it to Duncan.
Councillor. I'm after that Councillor McInnes does not have a conflict of interest to be allowed to remain in the room, but not. Sorry, no, I'm not. I know. I think you need.
Yes, sorry, through Chair. The process is first determining whether the conflict, and then we're mixing up with the order.
Okay, yep.
Sorry.
I just needed to.
Happy with that, Councillor West? That's right.
Yes.
Okay, thank you. Happy to second that. So any further discussion or?
No, I'm just happy to take the vote, thank you.
Yep. Okay, those in favour? Those against? The motion is equal. So we progress with orders, and I'll move that Councillor McInnes.
Sorry, do we need the commentary in there about being equal, so it's then decided in favour of the motion, against the motion? So does he have a conflict of interest or doesn't he?
I think the ruling, and I'm happy for governance to confirm that, is that if it is not determined that he does not, it automatically refers to that he does. I'm happy for governance to clarify that.
Thank you, Chair. That's correct. I believe Sharon is just putting that there now for
Yeah, I'm
clarity.
just making sure the clarity's in there. That, yeah.
Yep. Yep.
Thank you, Sharon. You've caught up. Thank you. Doing a great job. So I'll move that Councillor McGuinness is allowed to remain in the room, but not participate in the vote in determining Councillor Christensen's conflict of interest in item 10.1.
Just if I could, Acting Chair, maybe the wording that was used above may have been correct, because remain in the room doesn't allow him to participate. So what was used for
Councillor Chalk.
Councillor Chalk?
Yeah, happy for that to be. I think that was fairly similar, was it?
I wonder if you could talk up, Mr. Chair, because the public or myself can't hear you across the room.
Sorry, Councillor Swanborough. Happy to check that the wording is correct and consistent with the previous ones, Sharon.
It's more that remain in the room. Is remaining in the room participating in the discussion?
Well, the wording I have is, but not participate.
No, that's not participate in the vote, but you've got allowed to remain in the room but not participate in the vote. So remaining in the room, does this allow them to participate in the discussion?
Well, that's consistent with the legislation and the standing orders.
Yeah. Okay. Nice.
I think that's...
Thank you. Yeah, no, I was just
goes to
clarifying. I wasn't
yep.
saying nothing wrong.
Righto, yep.
Thank you.
And happy to second, Mr. Acting.
No further clarification. Happy to put that to the vote. Those in favour? Carried unanimously. So we now need to determine the mayor's, or you want to call an adjournment? Yep.
Suggest you consider an adjournment to allow us to refresh this.
Yep. Yes, okay, no, I'm considering the business at hand. I will adjourn the meeting for a return at 20 minutes, so 11:10. Thank you. Councillors, welcome back gallery, welcome back executive. I would just like to advise the council and the gallery that Councillor McGuinness, as previously advised to the Mayor, has left the meeting to attend a meeting with Minister Furner, Minister for Agriculture, Fisheries and Forestry, and propose a procedural motion that Councillor McGuinness be given granted, that's a better word, granted a leave of absence for the remainder of today's ordinary meeting. Make that the remainder of today's ordinary meeting. Thank you. Yes, I will just advise that all councillors can participate in the vote on this item as it's unrelated to conflict of interest arrangements. So I will put that as a procedural motion. We don't need a seconder, but I will put that motion. Those in favour? Carried unanimously. Thank you. Now, returning back to the business at hand, we're on item 5, declarations of prescribed or declarable conflict of interest. We have now determined who is eligible to participate in the discussion of Councillor Swanborough's declaration against the Mayor regarding item 10.1.
It's not against the Mayor, regarding the Mayor.
Regarding, thank you for that correction. So, Councillor Swanborough, you have outlined...
Could I just ask you to clarify for those in the
yes, thank you.
gallery who can participate or who can talk?
Mm-hmm. So as determined from the previous process, it has been determined that Councillor West and myself will be able to vote on this matter. Councillor Swanborough can speak and provide relevant information, and Councillor the Mayor will be able to respond as appropriate. We're all happy with that?
Thank you, Mr. Acting Chair. Mr. Chair, in accordance with Section 150 EW3 of the Local Government Act, I believe that Councillor Christensen may potentially have a conflict of interest in item 10.1, which I am required by legislation to notify this meeting of my belief. The reasons for that belief, I have 6 reasons for that belief. The first one, that as a reasonable person might think that he could be biased. The second one, that he has had past legal disputes or other personal reasons for strongly disliking me, and I refer to a Human Rights Commission legal matter that the Council is all aware about and has documentation. The third one is my action to the Queensland Ombudsman in 2021 concerning presiding over confidential briefings and the Council use of those briefings, and the protections against retaliation afforded me under the Public Interest Disclosure Act of 2010. The fourth one is that Councillor Christensen's possible motives in making referrals about me to the OIA. The fifth one is reporting in the media of the bias against me, the way he has chaired public meetings. The sixth one is the clear lawful notion in law that natural justice requires decisions by disinterested and unbiased adjudicators. In short, no one should be made a judge in their own cause in which they have an interest. This is a maxim in law going back to Roman times. In Latin, it's called nemo judex in causa sua, which means it is a rule against bias. Those are my reasons.
Thank you, Councillor Swanborough. I'll ask the Mayor if he would choose to respond.
Can I get clarification first? What was point 4, Councillor?
Point 4 is that Councillor Christensen's possible motives in making referrals about me to the OIA.
Yeah, I want him here. Okay. Without preparation, I will work through responding. The first one is a statement of opinion with no evidence, so I'm not sure how I can respond to what's simply an observation from the councillor's perspective. There's no reference to factual information there, so I don't believe there's any basis there for me to respond to that assertion. Point 2, I have not had any legal dispute that I have created or given rise to with Councillor Swanborough. Councillors are aware, and now the public are, because Councillor Swanborough did put it out in the public after the matter was withdrawn, and Councillor Swanborough had created a matter in the Human Rights Commission suing myself and the former CEO and seeking negative outcomes towards us on the basis of information that we never got to have a proper defence of because the matter was withdrawn. However, one of the matters there was particularly around the allegations of denying the councillor participation in a meeting which the OIA did properly investigate. It is shown on Council's website as having been found to have no substance to progress, and that was based off of a proper investigation by the OIA. I acknowledge that councillors, in the matter of resolving the future of the prior CEO, determined on that occasion by a majority of the non-conflicted councillors that I had a conflict of interest on the basis that I had been accused in that matter but had no point to respond. But at the same time, I'll remind councillors that they found the councillor who raised the matter not to have a conflict when considering a decision relating to the other party that they had sued. I've acted, so that's the matter that I've had. So to item 3, I have no involvement with the Queensland Ombudsman. I'm curious if the councillor is accusing me of retaliation. I have never taken an act of retaliation. I totally categorically refute that as a defamatory inference. There is no basis to that. I had no visibility beyond the same visibility that other councillors have of where those matters or when those matters were made public, I believe, by comments from the councillor, from my recollection. I've had no involvement with that matter with the Ombudsman, and it's just a matter, again, the factual evidence is there is no basis. I had no involvement and I have not taken any such action. Point 4, councillor, the allegation about making referrals to the Office of the Independent Assessor. Councillors, you're well aware of allegations in this regard previously by Councillor Swanborough. There has never been a matter that the OIA has indicated I have referred vexatiously or frivolously. There has never been a matter that they have considered to be inappropriate behaviour for me to have communicated as thus. I do have correspondence from the OAA that actually identifies very specifically that those statements that would have to be heavily redacted if I were to share it with council, because some of it pertains to other ongoing matters, but in particular it identifies that it is spurious to suggest, and I would challenge councillors to look at the councillor conduct register and find there where it identifies at any time that I've made an inappropriate or a vexatious or a frivolous complaint. If you go and look, councillors, the only vexatious matters on council's conduct register have been matters aimed at me. Don't know who by. Item 5, this is similar to what was in the previous declaration, which I referred the letter to earlier, and I'll simply say anybody who accepts that the perceptions of the media who don't always get balanced reporting, some do, some don't, but there are many in the media who don't seek balanced reporting and in fact take false information and publish it for the purposes of creating sensationalist headlines to try and sell to a particular audience. And even when they do seek interviews, they then falsify what is said in the interviews. And in terms of item 6, I'm not quite sure what the basis of the concern here. All I can say is, councillors, I walk into this chamber with a legislated obligation that I try to uphold without fear or favour. There is no doubt that the record shows Councillor Swamborough does have more exchanges in that regard, and I think informed observers recognise that quite often there are times where passion overcomes discipline in those conversations, that the chair has an obligation to try to calm and bring back into good process. For the most part, most councillors respect that and pause and respond appropriately. Unfortunately, that is the obligation, the same as the reasonable and respectful and proper obligation where matters come to attention to refer matters to the proper authority, being the Office of the Independent Assessor. I make no apology for properly and respectfully executing my responsibility to refer matters, not because of bias, simply because of the materiality of the matters, and it's up to the OIA to analyse matters independently. And that continues to be my position, because it is illegal for me not to refer matters where I have a reasonable awareness of them. That is actually the legislated obligation for each of us. So I don't take offence at reasonable and proper referrals against me. I accept them because they provide a chance for independent observation and outcome, as other councillors should as well. That's the process we now live under. I don't believe that gives rise to the notion of a bias, so-called. I believe even in the last time where these discussions of conflict of interest were had, I believe I demonstrated in that meeting fair and objective consideration, even though it was suggested I might have a conflict. I believe it demonstrated fair and reasonable consideration. That's the obligation that I take very seriously from this chair. Again, I can't respond to item 1 because there's no materiality to it. It's just an opinion. You know, I'm waiting to see if there's further information I might have to respond to, Acting Chair.
Councillor West, do you have any questions at this stage?
No question.
Okay.
Do you want me to reply to that?
Happy for you to respond, Councillor Swanborough.
Look, I refute what's been said pretty well on every issue. I'll start with the first one. The legislation requires, under law, that I declare that a reasonable person might think you could be biased. It is an opinion and it is a suspicion, and that's what the legislation says. It uses those two words. It says, do you have a belief or do you have a suspicion? And that suspicion has to meet the test of a reasonable person. So that's why it is there as number one. It is not a question of fact for people to determine or not, but for the accused person or the subject person, rather not the accused person, the subject person, to say that that lacks substance. It doesn't. That is completely substantial. The second one is when I said he has had past legal disputes or other personal reasons for strongly disliking me. That comes straight out of the guide produced in the local government department, and that particular issue, and it said that that has no standing because it was withdrawn. It was withdrawn because it was being used to declare conflicts of interest against all other councillors in this room, not all of them, but at least four of them.
Point of order, Chair.
Yes, ma'am.
That is factually misleading the chamber. That is factually misleading the chamber.
Yes.
That is a significant charge, and
Yes.
Mr. Acting Chair, I need to remind you what Councillor McConnell reminded you of earlier. You cannot, under the standing orders, use a point of order simply because you don't like what someone's saying or it's a breach of fact. If the Mayor can say, under the standing orders, which of those three sections has been breached, then you should accept the standing order. But if it's not the case, then you should not allow him to speak on the matter.
Well, Chair, I'm happy to clarify.
Thank you.
The matter was nothing to do with other councillors' conflict. Why I believe the councillor is misleading the chamber, the conflict of interest.
Mr. This is going beyond what's reasonable,
Councillor
Mr. Acting Mayor.
I think this is fair that the Mayor responds to that as a point of order. So
Only asks for what basis is he using a point of order to interrupt me.
factual correction.
The councillor is providing false information.
That is not a reason to interrupt a speaker under the standing orders, Mr. Acting Chair.
I think
I
that
thought truth
certainly
and
is.
integrity were important.
That's correct. Yep. Happy for that.
I have a right under standing orders to speak uninterrupted. Unless the point of order is about three things, and I'll ask
Chair,
Councillor McConnell to rule
I'll
on.
be happy to wait and then I'll respond, but I believe I'll put on notice that I'll be moving that the council has gone beyond good meeting conduct.
Thank you, Mayor. Continue, Councillor Swanborough.
Thank you, Mr. Acting Chair. Mr. Chair, Council was legally represented in a mediation in relation to the Human Rights Commission. It was alleged that every councillor in this room would be named as a respondent, and they weren't in that particular thing. I withdrew that because we were discussing the implementation of a majority decision of Council not to renew the past CEO's contract. And this Human Rights Commission action did not go to law, to a hearing, because I decided to withdraw that particular matter in the interests of progressing a council resolution, and it was getting in the way. It was referred to the OIA, as mentioned by the Mayor. However, the OIA did not consider the witnesses that I was calling for the hearing and the witness statements that were being obtained. of people who were standing 3 foot away at the time from conversations. So that's that particular one.
This is egregious misuse of process to defame me, and I'm glad this is being recorded.
That's good. Councillor Swanborough, I'll ask you to move through those points I think we've addressed on this point. Move on to point 3.
I have every right to raise the suspicion, and I'm trying to make the point to the other councillors who are involved in this decision that there was a legal action, a legal dispute between myself and Councillor Richardson in that Human Rights Commission legal action.
It's okay, he never gets my name right, I expect it.
Christensen, did I say? Councillor Christensen. My action to the Queensland Ombudsman is well known, and I have a letter from the Queensland Ombudsman, which I'm happy to read out a section of that. And it says, in conclusion, this is dated the 4th of November 2021, he says, Council has been reminded that your complaint was assessed as a disclosure under the Public Interest Disclosure Act 2010 and advised that notwithstanding the discontinuance of this investigation, the protections under the PID Act still apply. Council has been reminded by the Ombudsman. It is not truthful for Mayor Christensen to say he was not aware of this particular action. The fourth one is that Councillor Christensen's possible motives in making referrals about me to the OIA. The OIA didn't consider possible motives. They only considered that there was a legal obligation to refer. And I make no apologies for that, and I'm not accusing that has been... I don't say that that's something that he shouldn't do. That is fine, he could do. But it does not, the OIA does not look at a person's motives. What are the motives? One might be that you have to comply with legislation. There could be many other motives being used to generate those complaints, and that's what I'm saying the council needs to consider. Would a reasonable person think that there were any other motives in making those complaints? And as you know, multiple submissions to the OIA inquiry say that this process has been abused by many councils and has been used as a political weapon to slow up councillors and tie them up in red tape and all sorts of things. Those are the allegations made in the OIA inquiry. And I'm saying those possible motives, it's not a question of vexatious and frivolous complaints. It's very difficult to reach that threshold with the OIA, but that doesn't preclude the fact that people's motives could not be sometimes honourable in making the number of complaints to the OIA that a single councillor has got. And I'd say I'd probably be the most complained about councillor by internal complaints than any other councillor in Queensland about this. So that's what I asked the council to consider in relation to whether there is a conflict of interest of Councillor Christensen. The fifth one is reporting in the media of the bias against me, the way he has chaired public meetings. You cannot say that the media, always gets it wrong. The media is there to inform the public of decisions and how they are derived at in this meeting. We have multiple papers in this region, and they all are saying the same thing. They listen and make objective judgments. So it is very difficult to say that they're all wrong and one person is right. Number 6 is the clear motion that natural justice requires a disinterested and unbiased adjudicator. I don't believe that councillors around this table could think that Councillor Christensen is disinterested and unbiased in relation to any conduct matters that come before this council in relation to myself. And so, I stand fully by those 6 dot points that are made in this submission.
Thank you, Councillor Swanborough. I'll ask the Mayor if you would like to respond.
I'm not sure there's, apart from, I will go through A reasonable person is an interesting definition. I have plenty of reasonable people who are horrified by the garbage that's thrown upon me, both in here and by some councillors in their column, and also by some parts of the media without fair and proper balanced reporting. So the reasonable person is an interesting definition. I have a wide range of people in the community who feedback very strongly that they are reasonable people and they are horrified with that being bestowed upon me. In terms of my dealings with Councillor Swanborough, the public record shows all of my dealings are proper and balanced and in respect of the standing orders or the legislative requirement. And I understand that some councillors don't feel comfortable with that, but I have an unrelenting commitment to the integrity of the chamber, which is why I self-report any time there is a matter raised against me. I self-report so that it gets independently considered, because that's the standard I expect. The councillor's right for clarity, given that he's opened a whole heap of Pandora's box in item 2. I have not instigated any legal action against the councillor. The councillor commenced an action in the Human Rights Commission against council, myself and the CEO for clarity, which raised the prospect of other councillors potentially being dragged in by association with the first part of that. However, the matter did go to a confidential conciliation or mediation conversation, at which time, and by the way, the timing of that becoming visible was after the original decision on the CEO, when there had been no conflict of interest identified or admitted to by the councillor or supported by other councillors. The advice at the time was very clear that suing someone was a conflict of interest that could not be ignored, which was why we went through the process of, I went through the process of instigating a special meeting at the time, as councillors will recall. The matter was subsequently withdrawn, and then of course it was made public by various parts of discussion outside of my control. And there has never been an opportunity for that to be tested and found to be failed, except that the OAA did properly investigate, and the OAA have communicated again recently that there is no basis in those matters that were pertaining to the allegations around excluding the councillor from a meeting. And so there's no substance there. And that's long water under the bridge from my point of view. I just shrug my shoulders and press on with the challenges of council. We've got enough on our plate. The notification from the Ombudsman may well have come to the organisation. I don't believe it came forward by resolution to council or by workshop to council, from my recollection. So the notion that because it came back to council, somehow or other I'm aware of it. But even if I was aware of it or not aware of it, my issue remains, councillor, not about whether or not I have not taken any retaliatory action. And if you have had evidence to that effect, there is a process that goes through. And so I am quite clear and comfortable that at no time have I taken retaliatory action concerning the matters that went to the Ombudsman. The reference to the OIA is amusing, the questioning, and I refer to another recent correspondence from the OIA. I refer to my previous comment that local government officials have a low threshold statutory obligation to notify the assessor about councillor conduct. Those notifications should not be referred to as complaints. That is what the legislation, which we hear a lot about pieces of the legislation, this is another piece of legislation which simply places a requirement not to try and go and sort things out behind the bike shed or over a coffee. It actually requires the referral so an independent body deals with them. I am thankful for that independent body. I've talked with former mayors who had to try and deal with this, and it drove them to the edge of despair. And I'm glad to have an independent body who plays that role objectively, and they err on the side of not progressing matters rather than in progressing them. So that always gives that balance from my experience and observation. And I make no apology for simply fulfilling my legislated obligation without fear or favour. Once again, I respond to that statement. In terms of the media, well, there will always be a range of views about what is or isn't good journalistic reporting. Certainly, there have been some recent evidences in a particular publication which show a total neglect of good journalistic practice, and those matters will be demonstrated in full time. The last notion, therefore, I sit here before you, councillors. I have an objective commitment to the integrity of the chamber. I do try to exercise latitude, which I believe is shown over time. Unfortunately, latitude often is taken for licence, and then you've got to pull it up and everyone doesn't like it. I am interested only in the good performance of this council, and I am tired of this constant barrage of having to try to defend that against the basis of rumour and innuendo that continues to come up. And I would point out to the chamber that go and look at the councillor conduct register and find the evidence that says I've acted inappropriately and acted with bias. And the reality is there is no such evidence. There is no evidence of making inappropriate complaints or referrals against Councillor Swanborough. I try to fulfil my role without fear or favour, fairly and objectively, each day.
Mr Acting Chair, just one small quick point. Councillor Christensen was found guilty by this council for OIA.
Councillor Knight, I'm happy to have this.
Yeah. Councillor Richardson made all sorts...
Sorry, point of order.
Councillor Christensen, I said.
I'm Councillor Christensen. You often misspell it, but you're also now having trouble saying it. Can you please at least have the respect to get my name right?
Thank you. Yes, I do struggle with the name. Councillor Christensen, if you look at the register, put a complaint in against me in the very early days in the very first meeting that I ever had with him, accusing me of saying all sorts of nasty things about him, and that was dismissed. That was referred to the council as inappropriate conduct, and I believe it was dismissed by the council as inappropriate conduct. So it's not true that you have not ever made allegations that have been upheld by the OIA process.
Sorry, Councillor, you have misled the chamber once again. Chair, if I may.
Certainly.
The matter that was found by a majority of unconflicted councillors as inappropriate conduct was about a comment made during a workshop setting that I believe you probably referred as a comment aimed at you. That's what was referred, and the rest of the matters came out in the investigation. I can speak about that matter, and I'm happy that the council has given me an opportunity to, because I sought a copy of the investigation under RTI. The investigation found the matter unsubstantiated. And I'll remind councillors that a majority of councillors in a closed meeting that denied me the natural justice that we hear often in this chamber spoken about, found me guilty, even though the investigation found it unsubstantiated, I have no idea what evidence was looked at to make that determination because it was in confidential. I have no idea. I had no opportunity to respond to it, but clearly it wasn't the independent investigator's report. So thank you for the opportunity to put that on the record, Councillor. That was the matter that was found. So thank you. Again, I continue each day. I accepted that decision, by the way, and have sat in silence for a long time to try and restore a good faith behaviour in the chamber, the same as I've done on multiple occasions, as Councillor McConnell asked the last time this came up. And I will continue to try to act to build good faith. It is just very tiresome that every time I do, I get trampled in the mud. And I don't believe that's proper behaviour or befitting what is good for the future of this region. Thank you, Chair.
Councillor West, do you have any questions or further clarification required?
No, I don't have any more clarification. Thank you.
Okay. Well, I think we've had adequate time to consider and given both parties the opportunity to provide their case. I will propose a motion that Councillor Christensen does not have a declarable conflict of interest in relation to item 10.1 of today's agenda.
I'm happy to move.
Second.
Yeah, sorry, to second. But I would like to make some comments if I may.
You certainly may.
Thank you. Look, I really just want to reiterate the fact, really, with the Office of the Independent Assessor, and it is a legislative requirement, whoever the Mayor is, whoever the CEO is of any organisation, that referral, or even for us as councillors, that referrals are made to the Office of the Independent, to the OIA, and it's not about the motives behind or the sort of the dobbing in of people. It's about letting the OIA have a look at the situation, review the situation, and see if there is an issue there or not.
Thank you, Councillor West. I will also speak. I think it's been good that these 6 items have been brought out, and I think that both parties have had adequate time to respond. Councillors, this process is about moving forward. This process is about understanding our roles. This process is about the importance of conflict of interests so that we can properly carry out our roles as councillors. I totally understand that we've got 7 very passionate people who represent our community around this table. And not all of our interests will align, but certainly we need to be here for the benefit of our community. We need to move forward, and we need to be cognizant of different views, personalities, and always ensure that the process we follow is appropriate. I think these items that have been raised have been dealt with appropriately. I believe that the responses have been complete, and I hope that from this process we can put these behind us and progress forward so that we can, as appointed by our representatives, or of our constituents, to represent them in the community. So I will now put the motion. Those in favour? Those against? The motion is carried unanimously. So on that item, I now will return the chair to the Mayor.
Thank you, Councillor Enright. Now, thank you, councillors. Now, Councillor Swamborough, you wish to speak more to your potential conflict of interest?
I wasn't sure that I was going to be afforded this opportunity.
Well, Councillor, that's the next step on the agenda. That's the next step in the process. We've dealt with everything preceding it. So now we return. You've indicated...
Yes.
So please continue.
Look, as pointed out before, on the subject of I'm in the conflict of interest. I'm referenced in the item on the agenda. It is a matter of just a referral. I don't believe it's a conduct matter. I don't believe that I have a conflict of interest, but I was happy to put it to the meeting to decide as a declarable conflict of interest.
So any discussion, questions for the councillor or councillors? All councillors are participating, again, just to bring that to clarity. Councillor McConnell?
So just in relation to this one, it's a bit of a tricky one because it's not actually dealing with the orders and imposing them. It's the review. Sorry, let me go back. I won't call it a review. That'll be wrong. It's for the Minister for the department to have a look at the orders imposed. So is that really a conflict for Councillor Swamborough to have that, what really is, and which we've been identified, there is no appeal process apparently in regards to discipline issues. Is this a conflict when all the motion is to defer it to the Minister to to review it, basically?
Sorry, Councillor, can we just... you're talking about the content of your...
Which is what?
Notice of motion. I didn't realise... I thought your notice of motion was still linked at a different point in history. So that's why...
So all I'm saying is this is basically a review of the orders. So it's not... You know, Councillor Swamborough should still be able to have the right to vote that they go to the Minister for looking at.
Sorry, just as a point of order, Councillor, that's not the notice of motion that you've tabled to the meeting. The notice of motion that you've tabled, so the item before the Council that we're considering his involvement with, according to me, that the orders imposed on Councillor Derek Swamborough in items 11.23 at the ordinary meeting 11 October 22 be deferred until Councillor Swamborough has exhausted all levels of appeal.
No, there was another subsequent email.
I'm sorry, that's the report.
Through you, Chair. The amended, what was suggested to Councillor McConnell was an amendment, but that was pre what was put forward in the motion. So advice was sought, and at the time of the agenda being printed, the original submission for that notice of motion was put into place. The amended part, which was suggested by governance, hasn't been reflected on the agenda item, but I guess it's determining which one is now. That's a part after the agenda.
Change to the motion, to the notice of motion in relation to advice that was given by the department.
Thank you for that advice, Councillor. But it just makes it confusing what we're dealing with. The consideration is whether the subject councillor of the original resolution has a conflict in considering how this is dealt, firstly, and then how to deal with that conflict. Remember the two steps. So I'm just clarifying so that we... whilst we haven't varied it yet, note those comments about intent to change the resolution. Any other comments or questions, councillors? If not, Councillor Swanborough has, I believe earlier in the discussion today, I just need some clarity that because the matter relates, that the resolution before, the notice of motion before us relates to the resolutions relating to a previous resolution involving Councillor Swanborough as the subject councillor, that status cannot be ignored. Is that the correct understanding? Can I seek some input from a governance point of view, just from a process point of view, councillors, to understand?
That's correct, Mr Mayor. And as raised previously about the declaration, it was identified that what we're dealing with before was a conflict of interest. This note of motion also relates to the other matter. So the LGA understanding was referred to decision making in relation to the matter, which can be referenced to the original matter. So in effect, that's what you've indicated.
So I believe that says, I need to get this clear, I've been sitting in a different chair for a while, that it's almost automatic. We don't have to make a resolution about whether or not, it's about how to deal with that. Is that correct?
That's correct. As referenced to that section in the standing orders that we read out before, that prescribes what's the appropriate steps and the metrics of it.
Is everyone comfortable with that clarification? So really we're just now dealing with how to deal with the conflict. I'm happy to propose that, to move this forward at midday, that Councillor Swanborough remain in the meeting for the discussion of the item, given there is changing information, don't put that in, for the discussion of the item, but not participate in the vote on the matter.
Happy to second, Mayor.
Yep. So I'm just moving that from the chair, and I believe it's been seconded by Councillor Enright. Any discussion to that, councillors?
Mayor, I think we need to be absolutely crystal clear about what it is that we're dealing with in this declaration of declarable conflict of interest. We've determined that Councillor Swanborough is the subject councillor, and I firmly believe, and I believe the people that I represent would also agree, that he should not play a role in determining how the orders are dealt with, and this needs to show that clarity to ensure that there is confidence in our community about the process that we are progressing.
Thank you, Councillor. If I add to the discussion, for me, this is, I think there's a place for having all of the information available in the consideration, and then I just think then there's the proper process about how to vote on the matter, which shows that prudence. Any other discussion, councillors? If not, we'll put the motion. I don't need to speak any further this time. Anyone speaking against? Councillor McConnell?
Yeah, I will speak against, because we've already dealt with 11.2 and 11.3. We've made our orders. This is basically allowing the councillor to vote to have an appeal, or to have it referred to the minister on the decision, and I don't think it would be against anyone's public interest that he be allowed to vote for it to go to the minister for review to have a look at the decision.
Thank you, Councillor. Anyone else wishing to speak for the motion? Anyone else wishing to seek leave to speak against? I have no need to close. Put the motion. Those in favour? Those against? The motion is carried 3-2. Division, Mayor Divisions 3 and 4 in favour. Those against 2 and 5. Okay, thank you, councillors. There were no other declarations before us today. So I have no announcements before the meeting today at item 6 or deputations. So we move to confirmation of the minutes at item 8. And I note we have a recommendation that the minutes of the ordinary meeting held on the 22nd of November 2022 be adopted. Councillors, we've had access to those. I seek a mover. Councillor West. Any discussion, councillors, to that? Any concerns to the minutes? Seek a seconder. Councillor McConnell. Wish to speak, Councillor West?
No, thank you, Mayor.
Anyone wishing to speak against? Anyone seeking leave to speak additionally? Put the motion. Those in favour? Carried unanimously. Thank you, councillors. Business arising. Not aware of any today. We come. Sorry,
just one, Mr. Mayor. I think it was the meeting of the 11th of November, where I moved a procedural motion that the Minister review the conflict of interest raised by the Mayor against all councillors, and I believe we've had a reply, and I'll await the report that comes to Council in the new year for that.
So, just for clarity, that was reasonable suspicions, councillor, not conflicts of interest.
So, okay, just change that to review the reasonable suspicion.
Thank you, councillor. Move to item 10.1, councillors. CEO, were you going to introduce this or hand straight over to Councillor McConnell?
Sorry. Through you, Mr. Mayor, hand over straight to Councillor McConnell.
Thank you. Councillor McConnell, used to introduce this. Thank you.
Yes, if I could please, Mr. Mayor, this is, I'll just give you the amended motion or notice of motion that was sought after with governance and the department after the notice of motion was given. So we're a bit late in the change. It didn't make the report. So the new motion, notice of motion, will be that the orders imposed on Councillor Derek Swanborough in items 11.2 and 11.3 at the ordinary meeting on 11 October 2022 be deferred until the Minister for the Department of State Development, Infrastructure, Local Government and Planning determines whether the resolution to impose the orders on Councillor Derek Swanborough be revoked pursuant to Section 121 of the Local Government Act 2009. As we've already found out, there is no appeal process in legislation, so I dare say there'll be something coming in the future years to enable fair justice. So I think it speaks for itself, and I think we've spent enough time on talking through this. So happy for that to go.
Any questions to the councillor? I have one point of clarification, if I can. You made a comment earlier, Councillor Swanborough, but it's probably appropriate to get it clarified. Councillor Swanborough, just as a piece of information, I heard it in the debate earlier, but I understand that rather than what was previously advised in a prior meeting, you are advising the meeting today that you're not pursuing an appeal process. You're asking the Minister to review the decision. That is a change of position from previous information to the chamber. Is that correct?
Mr. Mayor, I've written to the Minister and provided a copy of that advice to the CEO, indicating that, yes, look, I've reviewed the legislation and technically it's just a procedural thing, really. Under Section 121, you can't make a direct appeal. But what I'm saying is that you can make an indirect process, because the advisor that's been appointed to council to examine a whole lot of things reports back to what the Act calls the Chief Executive, who is Mike Kaiser, who is the Director General of the Department of Local Government. He then has the power to make recommendations to the Minister about how he he exercises the minister's how the minister can exercise his right to remove unsound decisions from a local government. So it's not a question of I don't have appeal rights. It's a question of the process. And subsequent to my original application about the making an appeal, the advisor was appointed. Now I believe that advisor could have been appointed with some influence on the application I made to the minister as well. So, yeah, whilst there is no direct appeal process, there's an indirect one, and I have requested the minister to allow the advisor to make decisions in relation to these processes we've been doing, and to make recommendations to the minister about whether resolutions that have been adopted and processes that occurred should be repealed in the public interest.
Thank you, Councillor. I'm not sure whether that's quite how the process will work, but I noted all I really wanted was to understand, and I've been patient to let you have your say, what's identified by Councillor McConnell in his notice of motion is an accurate portrayal of where we sit today. I think the answer is yes. That's all I wanted you to confirm. So, because it's changed from what you had previously advised, and I wanted that clarity on the record, that's all. So thank you. And the discussion about the role of advisor is a totally different topic, which will get dealt with on a different day, unless the CEO wishes.
Sorry, through you, Mr. Mayor, can I just be clear? The governance advisor has been identified. However, that person still has to go through the Gazette process and be recognised there. So, again, think of the timelines associated with that. Think of the timelines that interact with Christmas and the holiday season. I reinforce again, they will come back to look at processes, frameworks, decision-making frameworks, conflict of interest they will cover. They will go back to the standing orders and go through the standing orders again, obviously leveraging off the model standing orders from the government. But please, this is not the governance advisor is not part of another appeal process. They're there to try and solve problems before they get to that point.
Yes, I understand that, but my letter to the minister asks that he does include that latter process you mentioned in his brief when he comes to the council.
Sorry, thank you, Councillor. There have been a lot of submissions in the background to lead to where we are on that front, so let's not try to confuse the two. We're dealing with this order before us now. Now, any further questions for Councillor McConnell or any need to clarify further, councillors? Just wanted to tie up that loose end from the prior information. If not, you're moving this, Councillor McConnell?
So moved, Mr. Mayor.
Seek a seconder. Councillor Chalk, thank you. Wish to speak further, Councillor McConnell?
No, I think we've covered it. It's pretty self-explanatory, Mr. Mayor.
And I second leave to speak against. Councillor West.
Thank you, Mayor. Look, I just want to mention I won't be supporting this motion today, and I know that Councillor Swanborough has written his letter, and that's fine. But certainly the information that I have seen and that Council have received from the department indicate that there is no process for appealing at all of these decisions, and that even Section 121 under the Local Government Act needs to be used with the Minister needs to be used very sparingly.
Thank you, Councillor. Anyone else wishing to speak in support of the motion? I will speak in support of the motion. Whilst I listened to the original discussion and consideration, and I know we've already had some correspondence that considered those resolutions, so long as this doesn't drag out forever, then I think allowing a reasonable time to give this objective consideration doesn't cause an impairment to us as council, so long as we don't end up in the situation where this drags on forever. And I'm sure we'll do our best with the department to expedite that conversation. I know they've been good in the past for doing that. And the pause button, not the removal button, but the pause button allows that piece of transparency to occur. before we progress with whatever is the outcome. Anyone else wishing to speak against? Wish to close, Councillor McConnell?
Just to say, I think this motion is fair and just, and I think the government in the background will be looking at something where there is an appeal process for any orders given. So, thank you.
Okay. Put the motion. Those in favour? Those against? The motion is carried 3-2. Division called. Mayor Division 2, 5 in favour, against Divisions 3 and 4. We move to item 10.2 on the agenda, which is tabling of the report from the Audit and Risk Committee meeting on page 8 of agendas. Councillors.
Through Chair, I'm happy to
Yes.
guide the CEO on this matter. Mr Mayor, Councillors, this report provides the Audit and Risk Committee meeting that was held on the 29th of September, and the attached report, which is made public, goes through the matters that were raised, and with the necessary commentary. I take the matters being read and certainly look to any seeking of clarity or queries.
Thank you, GM. Any questions for the GM, or perhaps I'll take the any additional comment from Councillor McConnell, who was attending remotely, if I recall, on the day, who is also a member of the Audit and Risk Committee. Any comment, Councillor?
No, I think it's self-explanatory in the report again, Mr Mayor. It's been quite a learning experience getting on the Audit and Risk Committee meeting, and I think the benefit that it brings to Council, especially the Chair and Melissa, is beneficial to all involved.
Thank you. Any question, Councillor?
Just a comment, if I may, Mayor, and I note page 12 of the report where the Chair noted it is a positive that Council has fewer issues within their statement than other councils. So that's a great endorsement of the process that we are going through in that audit and risk process.
Thank you, Councillor. Any other questions? I will return to that comment. If there are no other questions, I would add a comment. Certainly, not just the audit and risk process, but the indication of that from the auditors, that whilst there will be notes that and guidance that they provide us out of audits over time, the confidence we can have is that there is an ongoing level of strength in what is done as our processes, and that's evidenced in that comment. If there's no further questions, ask for the GM to introduce the recommendation. Thanks.
Thank you, Mr Mayor. The recommendation for item 10.2 is that the Council note the report provided on the Audit and Risk Committee meeting held on the 29th of September 2022.
Seeker mover, Councillor McConnell. Any further questions, councillors? Any further discussion? Seeker seconder, Councillor Enright. Wish to speak, Councillor McConnell?
No, again, self-explanatory. We're in a good place as observed by the Chair and also the Office of Audit. Thank you.
Thank you, Councillor. Anyone wishing to speak against? Seeking leave to speak additionally? If not, we put the motion. Those in favour? Carried unanimously. Thank you, councillors. We move to item 10.3, page 13 of today's agenda, and we turn to the GM, Customer and Regional Prosperity. Thank you.
Thank you, Mayor. Good morning, those listening online. Good morning, councillors and executive and those in the gallery. Item 10.3 is the Scenic Room Planning Scheme Draft Amendment number 3, and provides the outcomes of the consultation and the changes to the amendments that is proposed. I have with me the Manager of Regional Development, Health and Biodiversity, who's going to take us through this report. Mark Lohman. Thank you.
Thank you, GM. So this report is the finalisation of Amendment 3, which is a major amendment to the planning scheme. Probably to go back a step, when the planning scheme was first introduced in 2020, Council made a commitment to ensure that the planning scheme remained current and that amendments would be made on a regular basis to ensure that it stayed current, reflected Council's policies and views and the like. So since 2020 we've had an administrative amendment, a minor amendment, and this one is a major amendment. So the different types of amendments go through different processes. And in this case, whilst it's called a major amendment, the policy changes were generally fairly minor by nature, but it falls under the, the process of a major amendment, which includes public consultation. So the matters involved in this this amendment include matters that were a carryover from the second round of consultation for the planning scheme, matters that were not able to be introduced when the planning scheme was adopted and they were identified for a later amendment. And also, obviously, we've had time since the planning scheme was introduced, and some of the clarifications or minor flaws have been noted and have been corrected in this. So there were 20 different amendments proposed. I'll hand over to Heather Nelson, who's a Principal Specialist of Strategic Planning, to step through probably some of the more important ones. But then if there's any questions on those or any of the others that are not mentioned, we can answer those. Thank you.
Thanks, Mark. So just to reiterate, the draft major amendment underwent public consultation early this year for 33 business days. It's made up of 20 separate items, mainly just to improve policy matters that were identified through the early implementation of the scheme. So during the consultation period, a range of activities was undertaken to raise awareness of the amendments, and the opportunity to make a submission was made available. We got 28 submissions in total. 26 were not properly made, and 26 were properly made, and 2 were not properly made. So submission matters were raised on all of the proposed amendment items, with the exception of item number 14, which was about clarification of waterway buffer triggers. Most submissions raised matters related to more than one amendment item, which resulted in over 96 submission points that were reviewed and responded to in the consultation report. The key concerns that were raised in the submissions related to concerns about the amenity impacts of craft brewing activities, that the groundwater extraction for water supply on Tamborine Mountain must be supplied to Tamborine Mountain residents only, and that the land use should be impact accessible rather than code accessible, that the changes to the dual occupancy code would lead to unacceptable built form outcomes on Tamborine Mountain, that the proposed mountain community administrative definition of map not being a true reflection of what is considered to be the Tamborine Mountain community. In response to submissions, a number of changes are proposed to the amendments, including further clarification that groundwater extraction for water supply doesn't involve supplying water for use for intensive manufacturing. In terms of the amendment relating to subdivision in the rule zone, where the land is severed by a gazetted road, we're more clearly articulating that the planning scheme only contemplates subdivision where the land is severed by a state-controlled road. We're proposing to delete the note under the proposed administrative definition for mountain community, which referred to land on all zones and precincts on the Tamborine Mountain Plateau. The proposed note was not entirely accurate because some of the land is not strictly on the plateau, and some land on Tamborine Mountain is identified as a natural area in the strategic framework as opposed to being within the mountain community. Lastly, we're clarifying in the industry threshold description that leather goods manufacturing doesn't involve tanning or works for curing animal skins, hides, or finishing leather. The changes that are proposed are not considered significantly different to the consultation draft, and they don't require further consultation in accordance with the requirements for the Minister's guidelines and rules. So upon Council's endorsement of the changes to the draft amendments, we'd be seeking permission from the Minister to adopt the amendment package with a view to commence the amendment early next year.
Thank you for that introduction. The councillors, are there questions? And I'm just going to ask, if you have a lot of questions, can you give a very short introduction to your question, then ask one question, allow officers a chance to respond rather than trying to run through 20 questions because we lose track by the time we get to the end of it. Please just cooperate with that as a process. Short introduction, one question. Pause. Thank you. Councillor Swanborough.
Yeah, my question is in relation to something that happened 2018, I think, when the new planning scheme was put in place. Why was land in the mountain community designation at the base of Tamborine Mountain included in the planning scheme as the definition of what the mountain plateau was? Was this a mistake that was made at the time?
No, it wasn't an error. So the zones that apply to land on Tamborine Mountain include land that's in the Escarpment Protection Precinct. And the purpose of that precinct is to protect the values of Tamborine Mountain. So technically some of that land isn't in the suburb of Tamborine Mountain. So the boundary doesn't strictly reflect the suburb boundary. And the mountain community area also excludes land that's in the conservation zone on the Tamborine Mountain Plateau. So there are areas in the conservation zone itself, in the middle of Tamborine Mountain, that are also not in the mountain community area.
Okay, so within that land at the base of Tamborine Mountain, not necessarily on the plateau,
Yep.
is any of that land developable land? Could we put a housing estate on it or anything like that? Or is it all of it in the Escarpment Precinct or Conservation Precinct?
Yeah, if it's not in the suburb of Tamborine Mountain, some of it's in the Escarpment Protection Precinct and the rest is in the conservation zone. So that land is not in the mountain community area. I wouldn't say it's not developable entirely. It's developable in accordance with what the Escarpment Protection Precinct allows under the planning scheme, which is very limited development. And a lot of that land is affected by landslide hazard or steep slope overlay or vegetation overlays. So it's very, very constrained land. It's not really intended to be developed for any housing estates.
Further questions? Councillor Enright.
Thank you, Mayor. Question regarding item 4, amendment to the dual occupancy code and level of assessment for dual occupancies. What is the main intention of this proposed change to the dual occupancy level of assessment?
Thanks for the question, Councillor. So the main intent of this amendment to the dual occupancy code is to discourage the concentration of dual occupancy development in a particular area, mainly in the low density and low medium density residential zones. And this has happened in the past in Beaudesert, in greenfield development areas where, effectively a row of dual occupancies that look exactly the same has been developed. We're trying to avoid that happening. So too many dual occupancies in a street have unintended consequences in terms of the traffic assumptions for that road, poor amenity outcomes, parking on the street and that sort of thing. So this amendment seeks to encourage dual occupancies firstly on corner lots where they're over a certain size in that zone, and where they're not on corner lots we have a minimum size requirement, and then we encourage them to be dispersed and away from each other by having a distance requirement from an existing dual occupancy.
Thank you. Further clarification?
Subsequent question. There are a number of submissions appear to be from Tamborine Mountain residents. Was there any change to the dual occupancy level of assessment for Tamborine Mountain?
The amendment never proposed a change to the existing level of assessment for Tamborine Mountain for dual occupancies. They've been impact accessible since the commencement of the current planning scheme.
Thanks for that clarification.
Further clarifications, Councillor Swanborough?
Yes, Mr Mayor. The name Tamborine Mountain Communities featured a lot in the submissions that have been received. It seems that, we are appealing in calling this name Mountain Community rather than Tamborine Mountain Community. It seems that we're trying to appeal to the lowest common denominator in this thing, that because we've got a few blocks of land down the bottom, which is on the escarpment, we're going to rename, the whole of the plateau, take away the name Tamborine Mountain. which doesn't then identify the mountain as a distinct community. It's like taking away an identity. Is it necessary to do that? I mean, why couldn't we just still call it the Tamborine Mountain Community or Precinct, rather than calling it just Mountain Community, call it Tamborine Mountain Community, which would retain the identity. And this is what I'll be asking Council to consider later on, if that's a possibility.
Thanks for the question, Councillor. So it is a possibility. There's no reason why it couldn't be called that. I guess we haven't proposed the change because that was the way the area was defined in the planning scheme that was drafted, and it went through 2 rounds of public consultation. There weren't any concerns raised by the community in those consultation exercises. So this amendment really was only meant to provide a trigger map, so to speak, to clearly identify which land is in and out of that mapped area so that the special outcomes that apply to Tamborine Mountain can be more immediately evident to planning scheme users. There's nothing stopping us to make that change. It would be a major amendment, so it would have to go through another process. But I guess some of the submissions that we did see from this round of consultation that would contradict the mapped area because, like I said, some of that land isn't technically on Tamborine Mountain, so if it were renamed to the Tamborine Mountain Community, we're possibly going to have the same issue in terms of the mapped area not strictly being representative of what is the Tamborine Mountain Plateau or the Tamborine Mountain Suburb. You're still going to have land that's on the escarpment that's in Benoble or Tamborine in terms of a village. So I'm not sure if the name change is really going to have that desired effect either. There's still going to be a map that doesn't exactly match up to the suburb of Tamborine Mountain or what the community might identify as being that boundary.
Is there another solution to this? It seems like we're using a hammer to crack a nut here, a sledgehammer to crack a nut, and creating other additional problems for the community. And do we need to revise those boundaries to make it all fit one community? Is that not if we're going to do another major amendment, is that something that needs to be considered?
So just to understand, the reason why it wasn't limited to a particular community is because we looked at what the areas that were required to be addressed by the policies that followed on from that, and as I say, they extend over several suburbs. So, as Heather indicated, changing to another name is, it's council's choice, but you'll still run into issues with whatever you call it. So, mountain communities was seen as something which was consistent with the I suppose the topographical nature of the area. And sought to identify that it related to the issues related to the mountain community, including the escarpment areas.
Thanks for those clarifications. Further questions, councillors? If not, we do have a set of recommendations before us to commence the conversation. Oh, sorry, Councillor Swanborough, you have a further question?
Before we launch into that recommendation, I'd like to propose an amendment to that, or have I got to wait till it's adopted?
Councillor, you can't make an amendment until it's an active motion.
Yeah.
Only the officer can amend it at this point in time.
I foreshadow that I'm going to make an amendment.
Thank you, Councillor. GM, please.
Thank you, Mayor and Councillors. Before you today is a recommendation that 1, Council note the draft Amendment 3 consultation report. 2, that Council adopt the proposed changes to the draft Scenic Rim Planning Scheme 2020 Amendment number 3. And 3, request approval from that. Can I suggest Council go in there, please, in item 3, please, Sharon, that Council request approval from the Minister for State Development, Infrastructure, Local Government and Planning to adopt the proposed amendment in accordance with the requirements of the Planning Act 2016 and Chapter 2, Part 4 of the Minister's Guidelines and Rules.
Thank you. Now I seek a mover, councillors. Councillor Enright, thank you. Now, any further questions, councillors? Councillor Swanborough, you've foreshadowed you wish to discuss an amendment. Now is an appropriate time. Yes, Mr. Mayor. Microphone on might help, councillor.
Yeah, I'd like to propose that another item number 4. That in relation to item 11 on page 68 of the agenda, that Council change the definition of mountain community, or rename the definition of mountain community to Tamborine Mountain Community.
Sorry, just councillor again, please. You've got us all confused. Page 68, you said that's not in the amendment pack, that's in the comments pack. So you've lost us all, I suspect. So can we maybe stay in the report itself?
Yeah, I'll go back to the report, Mr. Mayor. Sorry,
Sorry.
Unfortunately,
If I may, through you, Mr. Mayor, maybe I'm unaccustomed to this, but was there a seconder?
No, not yet. No, not yet. We were just trying to. It wasn't yet. So I was just trying to deal with this before we sort that out, and then we can decide it.
No worries.
Happy to go to a second first, but I'd rather deal with this because I think this might need some clarification.
Okay.
I'll just remove references in the agenda, Mr. Mayor. I'll remove references to the agenda because, unfortunately, all my meeting notes were inadvertently left at home today, and I don't have them handy. So I can overcome that by saying that Council rename the definition of mountain community in the report to Tamborine Mountain Community.
And Mr. Mayor, if I could suggest some additional wording, if the council is agreeable, and makes the necessary consequential changes where the term mountain community appears throughout the planning scheme.
Sorry, councillors, private conversation without the microphones on doesn't help. If you want to speak,
Sorry, I was just
clarify.
I was just saying to Councillor Swanborough, we don't change the report. The amendment needs to be made to the planning scheme amendment, not to the report.
Just ask the planning manager if he thinks that that's the correct methodology.
Sorry, just before Mark responds, Mayor, could we just as officers get some clarity about what is being amended? Is it the actual report, the amendment?
So I believe that's part of the problem, and I have started this before we had a seconder, but that's okay. What I'm trying to, I believe it's seeking to amend the package going to the minister. And I think that would be, I'm concerned that this may actually then be in conflict with part 3 because I heard a comment before that said if we do that, that would require a different amendment package. Was that correct? So it would be in conflict with part 3 of the motion above. to deal with it that way. I'm trying to get that clarity. So firstly, let's deal with what the wording is first. Councillor Swanborough, I understand, is wanting the wording as it goes to the Minister, the pack to go to the Minister, to have a reference to, rather than mountain community, be Tamborine Mountain Community. That's correct, Councillor?
Yeah.
That's right. So does that give you the clarity you're looking for, GM?
Yes, well, I just also heard before just the clarification around major and minor amendments.
So now the next question is to understand the implication of that, Councillor, because it may actually create a conflict with other parts of the motion above. Because, and let me explain why.
Yeah, look, I was listening and I heard that. I also heard that it's something that could be done, so I'm just looking for ways of doing what I intended.
So would it be correct that in the wording as it currently is to the manager or the principal specialist, whichever, or the GM for that matter, that if that would create, trigger a major amendment which would be in conflict with the part 3 of the motion as it stands?
The answer, the answer to that is not black and white, Mayor. We need to determine, we as officers need to determine whether that actually involves a change to the planning scheme, a major change. So there's a range of criteria. At first look, it is probably okay, but I say that in that we need to probably go away and spend some time and make that decision.
Yeah, the idea is that if you're making a significantly different change on something that's already gone through public consultation, you need to go to consultation again. And there's a risk that the Minister might not agree with the change you made. Probably not so big for this particular item, but that's the risk. So we need to determine whether the change is significantly different.
Councillor McConnell?
Can I just ask how long we've called it the mountain community in the planning scheme?
Since the first draft went out for public consultation, that would be in 2018.
2018, so it's been 4 years. Yeah. When is the next major amendment due?
For general things, probably in the next 12 to 18 months, we would consider if there's enough material to require a major amendment.
So would Councillor Swanborough, it's already been 4 years, would it be agreeable that we just bring it forward in the next major change rather than try and get around and have to go back to consultation for a word change of one word?
Look, I'd prefer that we did it now. I may not be around in that period of time to see that occur, and I know it's from the submissions that have already been made. Whilst it wasn't clear back in the early days, and there were no submissions 2018, etc. It's well and truly out there, and there's a lot of representations to me that they feel that the mountain identity should be kept as a with the name Tamborine Mountain.
Councillor McConnell.
Should be kept as a planning entity for all future planning decisions.
Councillor, just given the uncertainty in the conversation, would you contemplate an extension of your proposed amendment to include wording that effectively says, after where it says Tamborine Mountain Community, go comma, should that be possible without delaying, or should that be possible, right at the end, after Tamborine Mountain Community, should that be possible within the current amendment timeframe? Otherwise, to be included in the next available amendment program.
Yeah, so just for clarity for me. So is the stickling point whether or not we need to go back out for public consultation on a change to a definition?
So just
So-
in conjunction...
Sorry, no, just pause. I'll explain, councillor. Part 3 says a specific action to move forward with the minister. If your amendment conflicts with that and creates a definite need to go out to that consultation, then it's in conflict with the motion. That's why I'm trying to create a wording that allows your amendment to be considered but doesn't conflict with the rest of the motion.
Yeah, I appreciate what you're doing, Mr Mayor, and I'm just trying to understand that is the test of that, whether it's in conflict or not, as is whether it needs to go out to public consultation again.
If I could, Councillor,
Yes.
in asking the Principal Specialist to answer that, could I also ask Heather to outline any other impacts that it might have across the other planning scheme instruments as well, so we understand the ramifications?
Okay, thanks. Yeah, so firstly, if a change is significantly different to what was on the public consultation version of the amendment, then yes, it needs to go on consultation again and holds up the process. The mountain community definition appears numerous times throughout the planning scheme. It's not a difficult change to make, but it's complex in terms of the number of documents that would need to be checked, cross-checked throughout the 828 Word documents that make up the planning scheme. It's used in the strategic framework, it's referenced on maps, it's referenced in all tables of assessment. There's a little bit of work involved, and effectively that would hold up progressing this amendment to adoption, and you'd need to prepare those maps for the Minister to approve as well.
Okay. Does that help clarity, councillor? So,
Yes, Mr Mayor, I don't intend to want to hold it up to that extent. There are some other things that I fundamentally agree with in relation to this scheme, but perhaps your original idea of referring it to the next planning scheme adoption would be
the wording,
Councillor McConnell.
So I think the wording for Sharon was comma where your cursor is. Should that be possible within the scope of the current amendment process and timetable? Otherwise, to be referred for consideration in the next available amendment pack. Major amendment pack.
I'm happy with that, Mr Mayor. Thank you.
Okay. Thank you. If you're comfortable with those words, councillor, then...
yes, I am. Thank you.
Moved any further discussion, councillors, before we seek a seconder for that?
Sorry, Mayor, can I just again seek clarity? The consultation report is not the right reference point.
No. So we said in... sorry, it should just be in the draft amendment...
number 3.
Number 3.
Not just the consultation form.
No.
This is the actual...
Draft amendment number 3, that's
yep.
correct. Whatever the right wording is. It says draft amendment number 3. Okay. Yeah, I know. Can we just? I know we're a bit out of sequence. That I should have had a seconder for the first motion. Can we just deal with the amendment? Then we can seek the advice of the mover, and then we can get a seconder to the whole thing. Apologies. It's been a long morning. Councillor McCollum.
So it probably just need, after draft amendment, it needs number 3 just to be consistent with the wording of the...
It's draft amendment number 3.
Yeah. Sorry, Sharon.
Okay. Seconder. Sorry. Yes, Councillor Enright.
Thank you, Mayor. My question probably is, in relation to this amendment, is do we have enough, are the words correct enough to provide the opportunity to explore the unintended consequences of this change at this time. So as long as we can capture that.
So,
Well, I don't know what the unintended consequences are.
So,
Yes.
so, Councillor, perhaps the way to think about that,
So,
if the officers determine it's not going to have material impact and it can fit within just as a definitional piece, then it'll be in. If the officers determine it's got significant impacts and does have to go as a major amendment, we either are stalling the matter to get further information. The idea of those words, I think the councillor agreed to, was about leaving that to the wisdom of the officers about where the right tipping point is. GM?
Mayor, could I also ask, with your forbearance, councillor, that after the amendment number 3, that we add the words "and further consequential changes to the Scenic Room Planning Scheme 2020, to the point that was raised by officers before, that it won't be just a change to that amendment number 3, it will have flow-on effect, which picks up the notions that Mayor put forward around the assessment that officers will need to do about its viability or not.
Does that make sense?
I think that's implied by the resolution myself.
So, yeah, I think that, but thanks for asking the question. I think it's clarified in it. Okay. Are officers comfortable that that gives them the guidance for action? Thank you. That's important. Righto. Now a seconder one more time. Councillor McConnell. Any further discussion? Councillor Swanbury, wish to speak?
I think it's self-explanatory. Thank you.
Anyone seeking leave to speak additionally? We put the amendment for consideration. Those in favour? Happy to support. That's unanimous. Thank you. Now, Councillor Enright, we should have had a seconder by now, but are you happy to consider your original motion with this amendment attached?
Yes, Mayor.
Now I seek a seconder. Councillor McConnell, you wish to speak? Any further questions or discussion to the motion, councillors? Not, Councillor Enright, speak to your motion.
Thank you, Mayor. I think it is appropriate to provide updates, deal with errors, provide improvements that are relevant, and keep our planning scheme fresh and current. I commend the staff on the effort that they have gone through, the 33 business days of consultation, the use of Let's Talk Scenic Room to enable this process to go through and come up with a suitable amendment package for our planning scheme. Well done to the staff.
Thank you. Anyone wishing to speak against? Anyone seeking leave to speak additionally? Councillor McConnell.
Yeah, I will reiterate what Councillor Enright said. I think the staff, the management and staff need to be commended on the processes taken in consultation, and although it's you can't always put everything in that comes through the consultation process, I think what has occurred is has enhanced the planning scheme going forward. So well done.
Thank you. Anyone else seeking leave to speak additionally? If not, I will speak additionally. Councillors, when we put the first combined planning scheme in place as required by the state, there was a lot of misinformation that we were taking a one-size-fits-all approach. In actual fact, we definitely weren't. We were trying to respect the uniqueness of many of our communities to try and address that. This package continues that process of trying to deal with those unique communities, give those protections where we need them, but also give the clarity for the future. We committed at that time to having regular amendment packs so that our scheme did not become stale. This is an example of that. Given the effort that's gone into growth management strategies in parallel with the development of this pack, I absolutely take a very deep bow to the skills and efforts of a really professional and capable team for putting this together in this way and considering that wide range of views. Thank you very much. I support the motion. Anyone else seeking to speak additionally? Councillor Enright, wish to close? We put the motion. Those in favour? It's carried unanimously. Thank you, councillors. A significant moment because we're also calling an amendment to go and have late lunch, which is doubly beneficial. Thank you for your consideration to that. But again, really, I congratulate the team. Thank you. And we will adjourn there at 12:50 for lunch. We'll return at 1:20. If councillors, that's okay, we'll keep moving.
Yeah, just a quick one. As soon as I did it, I think I realised I was wrong. But 15.5 of the standing orders, a councillor who proposes or seconds a motion must not propose or second an amendment to the motion, and I think I did both. So it wasn't until I'd done it, and then 2 seconds later it was all done. I went, hang on. Yeah.
Councillor, I did it out of sequence.
So no, that's okay. I was just saying.
I did it out of sequence because I did the amendment before the second.
Yeah.
But you're right.
Yeah. No, that's the daughter.
Thank you. Thank you, councillors. We return and resume our deliberations, and we are now at item 10.4 on page 182 of today's agenda. And again, GM, Customer and Regional Prosperity, we're in your hands.
Thank you, Mayor and Councillors. Before you today is the commencement of the major amendment to the Scenic Rim Planning Scheme related to protection of the matters of environmental significance and water resource catchments. Still in the room with us, we have Mark and Heather, and our Principal Specialist for Biodiversity and Climate Change, Josh Baker, has also joined us. So I'll hand over to Heather to commence this matter.
Thank you, GM. So this report outlines a proposal to commence a major amendment to the planning scheme, which seeks to update policy and mapping for matters of environmental significance and water resource catchments. Deciding to commence a major amendment is the first step in the amendment process prescribed by the Planning Act. Matters of environmental significance, or MES, are included within the planning scheme at the national level as MNES, the state level as MSES, and at the local level as MLES. In terms of matters of local environmental significance, the planning scheme currently identifies local biodiversity and water courses. Amendments to the planning scheme are required to ensure that as a living policy document, the planning scheme remains relevant and evolves in response to emerging issues and changing community values. There are a number of new issues that have emerged around the planning scheme's policy for MES and water resource catchments. Firstly, new data, mapping and regulation is available relating to Queensland's environmental features and biodiversity that must be incorporated into the planning scheme. These are known as matters of state environmental significance and include the examples of incorporating the new koala habitat protection regulations. Secondly, the need to consider the influence of climate change and the resilience of the environment ahead of new urban growth and residential infill has been identified, particularly through the recent growth management strategy process. Here, a body of work that reviews the matters of local environmental significance and another body of work that will consider local habitat corridors and linkages has already commenced. This early work will collectively refine and update the locally significant flora, fauna and ecosystem policy within the planning scheme. Finally, updates to the policy for the protection of water resource catchments will also be considered in this amendment. The purpose of the current water resource catchment overlay in the planning scheme is to protect the quality of water that's used for human consumption and urban purposes within the mapped water supply buffer area and water resource catchment area. And the code also ensures development is appropriately sited, designed and managed to maintain or improve water quality. As part of the Minister's approval to adopt the current planning scheme, Council was requested to consider advice from SEQ Water, which involved updating the overlay mapping in the planning scheme and ensuring that the policy to protect drinking water catchments addresses the impacts from activities such as animal keeping to maintain the existing groundwater hydrological regime. Council is also committed to investigating increased water storage capacity, so water tank options, for residential development within the rural and rural residential zones that are not serviced by reticulated water. Just like the process for the Planning Scheme Amendment number 3 that was just discussed, the proposed amendment will be known as Amendment number 6 and will be a major amendment. This means Council will formally undertake public consultation in accordance with the Minister's Guidance and Rules and the Planning Act for a minimum of 20 business days. Council officers will also be required to follow the Minister's guidelines and rules throughout the planning scheme amendment process. And in accordance with Council's current operational plan, this amendment will be fully scoped by mid-2023. Following community consultation, finalisation of this amendment is expected around mid-2024 or at the end of 2024, depending on the need for a second round of consultation. So today, following Council's decision to commence the amendment of the planning scheme major amendment and the first meeting of the advisory group, a notice will be given to the Chief Executive of the Queensland Department of State Development, Infrastructure, Local Government and Planning, seeking early confirmation of the state's interests that are included in the amendment.
Thank you for that introduction. Councillors, questions for clarification? The matter before us? Councillor Enright.
Thank you, Mayor. Thank you, Heather, for that introduction. Would you please expand on the comment about expand on the prioritisations of an amendment to the planning scheme prior to the amendments of the growth management strategy?
Yes, Councillor. So the growth management strategy process, which involved consultation, there were a few submissions that were concerned about the impacts of future growth on the environment. We see this as an opportunity to, first of all, update our matters of local environmental significance in our planning scheme, so that when future growth does happen, the best layers are in effect in the planning scheme. So the most up-to-date waterway layers, for example, protected vegetation. And secondly, the growth management strategy also recommended looking at opportunities to create biodiversity and habitat linkages within urban growth areas, so that there's opportunities for movement of flora and fauna, between areas of existing environmental significance.
Thank you. That's beautiful.
Further clarifications, councillors? If not, I'll introduce the recommendation.
Thank you, Mayor and Councillors. For your consideration before you is a recommendation that Council resolve to prepare a major amendment to the Scenic Room Planning Scheme 2020 to be known as Amendment Number 6, Matters of Environmental Significance and Water Resource Catchments, in accordance with Section 18 of the Planning Act 2016 and Part 4 of the Minister's Guidelines and Rules.
Seek a mover. Councillor Swanborough. Any further questions, councillors? Any further discussion? Seek a seconder. Councillor West. Councillor Swanborough, you wish to speak to your motion?
No, Mr Mayor, the report has the detail necessary. Thank you.
Thank you. Anyone wishing to seek leave to speak against? Seek leave to speak additionally. Councillor West.
Thank you, Mayor. Really just to reiterate, as with the previous item, the planning scheme is a living document, and so it's really good to see these amendments coming forward, and we have a very good consultation process now, and we will follow the process, so thank you.
Thank you. Anyone else seeking leave to speak additionally? To close, councillor? No, thanks.
No,
put the vote. Those in favour? Carried unanimously. Thank you, councillors. We move to item 10.5, page 188 of today's agenda. And GM, I'll ask you to introduce again, noting we have some other officers joining us.
Thank you, Mayor and Councillors. Item 10.5 is MCU 22/027. It's development application for a material change of use, a function facility at 168 FM Bell Road in Mount Alfred. Again in the room we have our manager Mark Lohman, we have our principal specialist, development assessment and engineering Joseph Kirkwood, and planner Frank Andrews, who I believe is going to take us through this matter. So I'll hand to Frank.
Thank you. Good afternoon, councillors. Yes, it's MCU 22/027. The application is for a function facility at the Karoomba Winery. As you know, Karoomba Winery is an established winery and restaurant and has been going for a couple of years now. The proposal is essentially they've been doing functions on the site for the last couple of years without approval. This application seeks to make this use lawful. The proposal is that there will be no construction. They'll be using the existing restaurant on site, as well as a chapel which has been constructed, which is about 100 metres south of the main restaurant facility. Now, the proposal is that they will be having functions, typically for 70 people, or they will have allowances for up to 100 people. Now, the site is located within the rural zone, and function facility triggers impact assessment. In addition, function facility is deemed in this zone as potentially consistent, which means the planning scheme in principle is supportive of such use, as long as the use can be demonstrated to manage the impacts on the local area and the local community. The application was publicly notified and 4 formal submissions were received. The location of the submitters were essentially mostly neighbours, located between 400 metres and 1.1 kilometres of the site. Now, just the summary of the issues. The first one was that the issues raised by the submitters, I might add, my apologies, was that was noise. Now, following assessment, we believe that the noise impact can be managed via noise attenuation measures, which will be conditioned. In particular, we will be requiring, well, in the proposed conditions, a noise management plan, which has to be approved by council prior to the commencement of the use. We condition that they commence a complaints register. The condition that the use be limited to 10 p.m. at the latest. Also limiting the noise generation at source to 80 decibels. No subwoofers or anything like that, and also we'll be adding the standard sort of noise impact condition that's one of our standard conditions, with regards to impacts on nearby sensitive receivers. The other issue raised in submissions was traffic safety on the roads. Now, most access to the site is via FM Bell Road to and from the east and north, and also Brent and Bunjurgen roads. These roads are sealed and have a rated capacity of 500 vehicles per day. The traffic report prepared on behalf of the applicant did a traffic counts for these roads and indicated that the traffic numbers on these roads at present is around half or less than half of that capacity. This same traffic report also projected that a 100-person function would generate 40 vehicle movements. We think that was probably a little bit sort of low because it was based on the assumption that every function would, 60 of the guests would be travel there by bus. However, the applicant in separate correspondence indicated only approximately 60% of their functions when they, which they have had buses. The rest were basically people, essentially driving themselves. So we consider probably the likely maximum traffic generation would be closer to around 80. Even with that greater number, the traffic generation is well within the capacity of the roads by a considerable margin. So we don't conceive any sort of safety issues with regards to the extra traffic generated by any particular function. The next issue was fireworks. In particular issue, with regards to the impact of the fireworks on livestock at the local area. We agree that this is a concern, so we have actually proposing a condition that they not set off fireworks associated with the proposed use. Some functions also mentioned helicopter joy flights. Now, this really is more associated with their day-to-day running as a winery, so it's not really something that's a relevant matter to the function, the facility application. And finally, the submissions revealed issues with regards to gravel washing off the driveway onto FM Bell Road. The applicant had indicated they do intend to seal their driveway, and so therefore we have conditioned, put a proposed condition as such. So in conclusion, we think the conditions that we're proposing to apply to this proposed development will manage and mitigate the impacts on the development. As a result, we are recommending the use be approved.
Thank you. Councillors, questions to the report? Councillor McConnell?
Just a quick one. Down on page 209 of the report, talks about further approvals are required. So the building works approval required for all buildings prior to any building work subject on the property that already been constructed?
Yeah, that's it's basically that's a sort of a standard thing we add to the report.
Yeah.
It's probably you're right. There's probably unlikely any construction, so we could probably remove that requirement.
It was more. Are they planning on more?
My understanding, I'm not aware of, certainly in none of the submitted materials, there's any indication of any further construction.
Okay.
The intention of that advice as well does allow for any reclassifications of existing buildings too, so it's a bit of a catch-all.
Okay.
Okay. Noted that. Okay.
And I just got to go back one. There it is. Condition 21, the complaints register. How often do we go out to the businesses and look at the complaints register? Is that something that's compliance does on a schedule? Or do we wait until there's an issue at a business before we actually look for the complaints register?
Thanks, Councillor. Yeah, so it's not a proactive compliance audit of complaints registers for individual operations. So it'd be only in the instance where council does become aware of a complaint as well. And then we would also action it via our normal investigation process, but it does give us an opportunity to go back and look at what mitigation they might have undertook or what information they took on board in terms of their own complaints management.
Okay, thank you.
Councillor West.
Frank, do I do Frank or to right, look, I'm sure you mentioned a noise attenuation wall. Did you not? Did I understand that when you were talking about the noise attenuation?
Sorry, what was that?
Speak close to your mic.
Sorry, noise attenuation. Did you mention a wall?
No, not a wall.
Oh, sorry. Well,
so we're just talking about noise attenuation as a general principle in terms of...
okay. That's right. I just wondered where that was, whether it was part of the noise management plan or the other conditions. Okay. I wasn't sure how open it is.
Thank you. Further questions, councillors? Obviously, there's a lot there in the conditions. Otherwise, we're noting the conditions. We won't ask you to read them all out, Jim, but we'll ask you to introduce.
Yeah. Yes, I'm thankful that the team has changed their process and used them as an attachment. So, councillors, for your consideration is a recommendation that 1, council receive and note the report titled MCU 22/027 Development Application for Material Change of Use Function Facility at 168 FM Bell Road in Mount Alfred. 2, that council approve development application MCU 22/027 subject to imposition of reasonable and relevant conditions in Appendix A. And 3, that council note that any subsequent request for negotiated decision notice and or change applications to the approval MCU 22/027 will be processed via delegated authority where the changes will not significantly alter the original decision.
Seek a mover, councillors. Councillor Chalk, thank you. Any further questions, councillors?
Just making sure that wasn't a new suburb and it was Mount Alford, not Mount Alfred.
Yes, it is
I
Mount
was just doing that
Alford.
to see if you're paying attention, councillors. Well done, you get the minties.
Thank you. Any further questions? Any further discussion? Seek a seconder. Councillor McConnell. Councillor Chalk, you wish to speak?
Yeah, thank you, Mayor. I will speak. It is a shame that we sort of pick this up through compliance, then that we have to do retrospective approvals after we've had complaints and we've had impacts on our neighbours. But I'm glad to see that they've come to council and they've got the approvals that they need, and then the council officers put the relevant measures in place to minimise any impacts. I do think it's a valuable asset for our community. It's very well attended and very well liked, and these conditions will ensure that the impacts are managed in a way that I think everybody in the community should be okay with. So I'm happy to support this today. And I thank the officers for their work.
Thank you, Councillor. Anyone wishing to speak against? Anyone seeking leave to speak additionally? Councillor Swanborough.
Yes, Mr Mayor, I'll speak in support of the recommendation. I think I went to the opening of this facility and I've been to many functions out there, never knowing that it didn't have an approval, of course. But this is, as Councillor Chalk has said, this is a very top-class facility. It's almost iconic in the west of our shire as a function centre for weddings, as a winery, and also as a lavender farm. And I believe that the conditions that have been put on this are correct and will address the concerns of the neighbours. No fireworks. And I think, it was always in the back of my mind, how come that driveway is not bitumen sealed? So for a development of this quality. And I'm very glad to hear that the applicants have voluntarily decided that they will seal that thing, and I think that will just top it off. And we can be proud of this particular venue, its professionalism in the Shire, and I fully support the recommendation.
Thank you. Anyone else seeking leave to speak additionally? If not, I will. This is a venue that actually has had some approvals in place, so we shouldn't be totally alarmed. There were approvals in place, but the use has changed, and I think this is a great lesson. Sadly, we have this occur in many places where there are historic approvals for a particular type of use, but the world of excitement that is Scenic Rim has created the desire to do additional things, and sometimes people get ahead with the opportunity without the full process. I agree with Councillor Chalk. It's great that they've responded well. We've been able to identify the gap. They've responded well, and we're now in a position to bring this into a proper control for the uses that are intended there now, beyond what was the original uses. So it's great to see this proactivity, and hopefully it's a lesson for others to talk early before commencing new uses. So I commend the motion. Thank you. Any further seeking leave? Councillor Chalk, wish to close? No, thanks. Right, those in favour? Carried unanimously. Thank you, councillors. We move to item 10.6 on page 269 of the agenda. Thank you, officers, for your assistance. And GM Asset and Environmental Sustainability, we are in your hands.
Thank you, Mayor, councillors, executive officers and those listening in online. Item 10.6 deals with the disaster recovery funding arrangements and an update of the 7 events that we're currently dealing with within our portfolio and others. It's pleasing to see that one of those events is all but substantially completed, that being the second event listed there, being South Queensland heavy rainfall and flooding, 8th and 14th of February. Look, I draw your attention to the second paragraph in the report around the complications of having so many events running at the same time. Have a team that go out and inspect. I feel for our maintenance guys who are dealing with repeated events, dealing with a road network that has been saturated for an extended period of time. It's not only our region that's suffered, it's others as well. I think, unfortunately, a number of records have been broken throughout not only Queensland but Australia as far as rainfall, and unfortunately also a number of potholes having to be filled on roads. As a result, there's quite a number of multi-dimensional aspects when it comes to actually undertaking the review of each of these events. When you have repeated damage, depending on what volume of repeated damage, that then takes that particular identified piece of work out of one submission, puts it into the next submission of to the QRA for assessment. In some instances, we've had some locations resubmitted or taken out of one submission, put in the next up to 6 times. It's interesting also to note that the first item that's listed there, the Queensland bushfires, September to December 2019, the usual case is that we have the remainder of the financial year plus 2 financial years after that to actually complete the works, which would put us needing to have this completed prior to now. We've asked for an extension of time because during the southern Queensland flooding of 6th to the 20th of May, there were substantial landslips in that area. But given that one's a flood claim and one's a fire claim, the two can't be added together, so they have to be separated. Also, that ended up with additional complications. We had a contractor that was awarded the work to actually undertake the repairs to the guardrail. Given the change in scope and quite a considerable change in the style and type of works, we mutually agreed to disband that contract and recall a contract concentrating not only on the guardrail and minor slope repairs, but also the major landslips as well. Look, I'll take the report and summary as being read, and I'm happy to take any questions from any of you.
Councillor Enright first, and I can see Councillor McConnell's then waiting.
Thank you, Chris, for that introduction. Just that last point where you're referring to the head road as that last item.
Yes. Yes, sorry. Yes, it is the head road, and it is still closed to traffic due to the damage that occurred at that location.
Thank you. Councillor McConnell?
Yeah, thank you very much for the report, GM. If you could, and hopefully the media are listening, if you just could go through the sequence of events once we have a rain event in regards to the fixing of the potholes and what works can be conducted that will ensure that we're reimbursed that money. So realistically, after a rain event, the first round is basically emergent works. In that you can in the emergency works. I'm getting used to the change in terminology, which involves any road closures, reopening, any temporary works that allow traffic to move through. It may mean some minor grading. Pothole patching is certainly something that does meet that criteria if it's linked to the event itself. Any seal repairs. Look, where there's substantial damage and the reality of it is, and look, generally speaking, emergency works for majority of these events were total to about $1 million to $1.5 million to do those specific works, whereas the long-term fixes can be 5, 6, even 10 times that amount. The other aspect to that is if you have a location that has been damaged repeatedly, we can actually apply for what is called betterment funding. And there are a number of locations, especially those that we can link back to several impacted events, as well as they run something called VFM, or value for money, across the particular aspects of the work. And if there's let's use an example of a section of road that gets washed out, costs $100 to fix each time it gets washed out, but for an extra $50, if we can repair it in a way that next time it rains, it might just be washing off the silt, which is a $10 activity. They certainly look at that as a value for money investment from betterment. I must say that previous events, in particular 2017 event, we were very fortunate to be able to to arrive at a position where we approximately $10 million worth of investment through betterment within the projects that we put forward. We're not thinking that we'll be in the same position this time because that particular event and others around it, there weren't as many impacted councils as there are right now. But we're certainly working towards identifying those locations. Now, in saying that, you generally only put in for a betterment application once the application for your submission is approved that there's work required. And quite often, to actually get the best value for any improved betterment is actually to undertake the work, undertake the work as part of the process of restoration. So we've had quite a number of roads that could be quite high in the volume of damage, but the reality of it is if we can actually get additional assistance in building back better, we certainly will. The compounding issue, and I guess I look back to the 2017 event where we went pretty much with quite an intense amount of flooding and rainfall and quite a substantial amount of damage. But after that, we almost, what I would class as almost perfect road building weather until probably 12, 18 months on, we ended up with being in the other extreme of having to hire additional water carts to cart water to site. So the reality of it is this time round, not only have we had the
rolling events, we've also had the compounding additional wet weather as well. Look, I say that understanding in the last probably 3 months, we've had a reduction in the amount of rain we've seen, but until that period of time, we were in quite what I would consider unusual circumstances with regard to the volume or number of impacted days we had during wet. And with any sealed road where there's any damage at all, we go out there, patch, and the most efficient way to fix a pothole is to patch it with premix. Unfortunately, when it's raining, it may not always hold because you try to remove as much water as you can out of the base of a pothole, but at the end of the day, if it's raining while you're trying to patch, it's damn near impossible, for want of better words, to describe it. And we may then find, you may, as a road user, say, well, there's that pothole still there today, but actually it may be the same hole that was patched that ended up, because of additional rain, failing again. So the reality of it is we certainly keep evidence of that, and where possible we'll certainly look at ways to improve the final outcome.
Okay, thank you. So once we get a rain event and we fix potholes,
yes,
we can't fix the actual problem until it's approved by state?
Well,
or if we do, we have to pay for it?
Yeah, look, I appreciate your question. The reality is we can. The issue is, though, where we need to have a level of a certainty that we're going to actually get the funding in the first place. So there's a risk, given the volume and the dollars involved, if we actually go and undertake the work without some level of assurance that it meets all the criteria. We don't, particularly as officers, want to put council in a compromised position where there's multiple and could be millions of dollars that haven't been accounted for in the budget. So so look, I'm being very careful here, because our officers, when we talk to the QRA or the Queensland Reconstruction Authority, they certainly say, we're not stopping you doing the work. We aren't stopping it. However, it's our own requirements to ensure that we don't put council in a position where we've done additional work or carried out repairs that may not necessarily be able to be recovered through the process.
Thank you. So
sorry, I was going to ask just a supplementary question to that.
No.
Just for clarity, have there been situations, without naming councils, have there been situations where councils have moved to act without the certainty of that feedback from QRA to the detriment of the financial outcomes of the council?
Yes, there has been.
Thank you.
Okay, so just going back, so the event's happened.
Yes.
We've patched it.
Yes.
Time frame before QRA gets back, and we've submitted to QRA.
Look, and look,
average time frame.
The reality of it is it depends, and I'm
just rough estimate, 6 to 12 months.
It could be anywhere from 3 months to a year.
Yeah.
Because
so
realistically, it depends on, and I'm being really honest here, the volume and number of claims that the QRA or submissions the QRA are having to assess at the moment. It is quite a thorough process, and understanding that they're accountable to the federal government, who fund the 75% of this, and also accountable to the state government for 25%. So the reality of it is we're unfortunately reasonably practised in what they want to see, and we've got some, and I guess I draw your attention to what we call RACUS damage assessment, which is basically taking not a video but still shots every 5 or 10 metres down each of the roads as soon as practicable after the event. It gives you that ability to trace between each event. Now, unfortunately, someone still has to sit and look at that, although there are some councils, and we have started to dabble in that sphere of actually using artificial intelligence to actually pick up differences in the pavement or edge wear or other missing signs and that sort of thing. But we're not there yet. But the reality of it is, look, to put a definitive time on it, look, I will say, if there's something of great urgency that may be looked at more readily and a lot quicker, and also there's the opportunity for officers to bring forward to myself, this particular road needs specific attention immediately. We then could bring it as a discussion to council to what level of risk council would be willing to accept as far as if we were to move forward on restoring.
Okay, so with the 12 months between when we submit and possible approval, we're required to continue to patch the potholes.
Yes, we do.
And it's not because we don't want to fix the road. It's a requirement that, as you said, we may not, if we do fix it properly, we may not get the funding. So,
yeah, it's a fine balance, and also there's an element also of understanding of how much is appropriate as what we call holding works. So you have your emergent period, then you have what is holding works, and then the reconstruction. Could be reconstruction, or it could be reconstruction plus benefit, a betterment.
Yeah, thank you. Thank you.
Further points for clarification, councillors? I'll get you to introduce the recommendation. Thanks.
Thank you, Mayor. The recommendation is that Council note the disaster recovery funding arrangements infrastructure recovery update as at 11 November 2022.
Seeker mover, Councillor McConnell. Further questions? Further discussion, councillors? I'd just add a piece of discussion. If you look through, if people take the time to look through it, there are 7 programs active going back as far as 2019 that the team are still trying to manage through with support from QRA, and that is compounded not just by the time frame for approvals, it's the ongoing weather patterns, it's the availability of teams, the availability of resources, and the overlay of those different events. Whilst this summarises down into a couple of pages, it probably doesn't give and I appreciate Councillor McConnell trying to identify some of those complexities, but that overlay of complexities, councillors, is there are a number of places that are mentioned multiple times. GM, I would just quietly suggest that occasionally we confuse Philp Mountain with Phillip Mountain, still sneaks in occasionally. Under landslips, it's snuck in again. And whilst we're always interested in a broader region, we probably don't need more mountains right now. But it really is a testament to the challenge that the team are working through with different timeframes for each of those matters to be worked through and different processes. So it looks simple, but it's pretty complex. Any other discussion, councillors? Seek a seconder. Councillor West. Councillor McConnell, you wish to?
Yeah, I will speak. I think the GM and his team and all those that deal with the grants need to be congratulated. Since 2017, it's been a huge effort by the team to be able to manage our road asset as much as it's not in the state that everyone wants it to be in. It is an ongoing task that's needed by the works team to prioritise which roads need to be done first, depending on the traffic numbers. And the fact that every time you fixed it up, it got hit by another rain event certainly didn't help. But hopefully the residents out there do appreciate the work that is being done and the complexities that evolves around patchwork until approval for funding, so we're not using ratepayers' money for something that is already budgeted in the QRA. So well done.
Thank you. Anyone wishing to speak against? Seeking leave to speak additionally? Councillor West.
Thank you, Mayor. Look, I just want to urge our community members to take a look at this document because it is very concise and as you can see, these are the challenges that our officers are dealing with 7 different events, and it just probably helps to understand the situation that's surrounding the payment of all of these projects, which is often hard to convey to the community at the time. But thank you, Chris, to your staff for this.
Thank you. Councillors, anyone else seeking leave to speak additionally? I'll just add one comment. I support Councillor McConnell's comments, support the motion, and I think yesterday afternoon there was a small turning of soil event where fortunately the digger had opened up about 300 mil deep of soil, but that was very wet clay that we were then doing the turning of the soil on, which highlights just how close to the surface the moisture still is and the challenge it is for getting able to start stable basis for reconstruction. So really applaud the team for their ongoing efforts. Thank you. Any further comment? Councillor McConnell, wish to close?
No, thank you, Mr Mayor.
Those in favour? It's carried unanimously. Thank you, councillors. We move to item 10.7, GM Council Sustainability, page 277. Please introduce.
Thank you, Mr Mayor, and yes, good afternoon to everybody, including our digital gallery that may be listening out there. Item 10.7 today for consideration is the September budget review. I will take it that the report has been read, but I'll put a bit of an intro to put things into context. Since Council adopting the budget on the 11th of July 2022 this year, we've gone through the process already of making an amendment to the budget in reflecting the carry forwards. Since that time, officers have now gone out and undertaken a budget review, which for those listening out there and to paint the context, a budget review permits the previously adopted budget to be amended. Changes to a budget may include where new information is received or circumstances change, and reasons for some of those changes may include a change in service level resulting in an increase or decrease in expenditure, a change in the grant funding received or for services or programs, projects or services delayed or stopped for reasons beyond Council's control, and also unanticipated increases or decreases in expenditure or revenue. They're the principles under which a budget review is undertaken, and the consideration in putting those forward is that do those amendments are they consistent with the long-term financial forecast of Council, and are they consistent with the operational plan of Council, and importantly, the commitment to financial sustainability by ensuring that the adopted financial indicator targets are met. That meaning that any amendments to the budget shouldn't place Council in jeopardy of not meeting those financial sustainability indicators. And the last two other factors for consideration are accountability and transparency in decision-making processes, as well as providing value for money for the service provided. That being said, Mr Mayor, again, I reiterate that I take it that the report has been read, but the high-level overview, if I'm to provide one, of what this September budget review indicates is that 4 key items. From an operating expenditure perspective, what we've seen is an increase in operating expenditure of around 3.139 million, but particularly that's offset by additional operating revenue of around 2.975 million. The operating revenue consists of additional $2.155 million in grants, with a corresponding $2.063 million in expenditure with those grants. What that means is, there appears that we've got surplus grants in revenue as opposed to expenditure. What that means is we've undertaken the works last previous year, but we're only being reimbursed this financial year. Similarly, from a capital expenditure side of things, we've seen an increase, and Chris has pointed out some of those associated with those previous events have now come forward as approvals. So we've seen a staggering $47.652 million in additional capital expenditure, and that's offset by $44.973 million in capital expenditure. So what we see, the overall cash impact in funding this September budget review is a utilisation of Council's retained earnings of about $2.844 million, but that funding is really funding capital, of that 2.844 million, 2.68 million funds capital expenditure, and 164,000 is funding the operational side of things. So from a general sense, there's minimal changes in an operational sense. There's some minor tweakings in between accounts and whatnot reflected in the September budget review, but the bulk change here today is reflected in the capital expenditure. That being said, Mr. Mayor, I'm certainly open now for any further queries as where required.
Councillors, open for questions of clarification. Thank you. Councillor McConnell.
Thank you, Mr. Mayor. If I could just go to page 281 of the report and the increases that the GM just indicated to capital expenditure. If you could just go through the second last paragraph and just explain how these additional increases in capital expenditure.
Could I refer that to the particular areas of those programs?
You certainly can.
And there may be a tag team between Chris and Deborah on those particular projects. So we'll start with the VATV business part.
Okay, thank you. Yes, the Badger's Enterprise Precinct certainly has been one, for want of better words, a casualty of the wet weather and increased cost of supply of materials. The original budget was $10.5 million approximately, $5 million of which was grant funded. Unfortunately, and I've got a list of some of the items that have gone over, and not in any particular order. General earthworks has almost doubled in price. Unfortunately, when we were starting the earthworks, that's when the wet weather and wet weather rework occurred. So there's about $1.1 million associated with that particular item. Also, drainage, retaining structures and protective treatments is just shy of $1 million extra in spend in that as well as sewer reticulation and pavement. So, and given that the site had to be occupied, it was occupied for over 1 year longer than anticipated. The overhead costs have certainly blown out as well. So there are some areas that did come in slightly under, but the bulk of it is initially associated with the weather impacts, which then flowed on into material increases in costs. So that's the bulk of that 1.331 million on that particular one. Now the next one's an interesting one. We've identified within the council there's a 2-year project to upgrade to culverts on Tyrone Road. To actually allocate or identify the grant in the budget, we've actually identified the full expenditure, which will then be a carryover because we'll actually be delivering the project next calendar year, but designing at this, next financial year, but designing it this financial year. And as such, we're offsetting the contribution to council from the long-term financial forecast. So what it sees is we're actually identifying cash that will be associated with that project that will be carried forward but not allocated to out of the long-term financial forecast for next year. Oliver, I'm hoping I used the right terminology there.
That's right, and obviously when considering those projects, it's just bringing that project forward so to get the commitment started. Obviously, council can't commit to next year's budget until next year's budget is considered, but bringing that forward, as Chris indicated, allows the work to start designing, and obviously that'll be one of those projects that will have that extended delivery duration.
Just a question while we're on that topic. The note here that it's offset by a reduction in the 2023-24 capital budget, perhaps that should be proposed rather than those words, because I am very uncomfortable about committing an approval for next year's capital budget when we haven't seen the whole program at this point in time. So, and I don't think it's good accounting practice to be committing or funding projects, future projects, this way in a current year.
Yes, that is correct. As Chris indicated, this project was originally intended, over a 2-year period, and the bulk of it, was for next year. But to get the project committed and started, it just meant that that was to be brought forward into 22-23. So it won't be it won't be double treated next financial year, if you know what I mean. So it was also there for next year, but that means it's offset by that reduction next year by bringing that works forward 12 months.
Just as a further point of clarity, does this have grant attached
Yes,
to
it
it,
does,
which I
yes.
think is a piece in the conversation, councillor, that it's actually funded from a grant which has that
Yes.
tied funding for that, which does need to be. I agree with your point about the clarity about that, but in actual fact, it's about the phasing of the application of the grant funding is what's being reflected in this change, which probably isn't quite as clearly described in that comment. Councillor Enoch?
Mayor, if I can just...
Can I just keep on that? Are you keeping on the same subject?
I want to go back to Bethesda Business Park, so if you're still on this one.
Sorry.
Yeah.
Right, no, let's tie this one up if this is on
Yeah.
those.
So, given the
from
fact
Rome,
that we've identified to bring the design phase in the year before, so that once we start the new budget year, we can commence the work, is that a standard that we may now keep? Because obviously,
When it's
we've
a
got Versdale
co-funded, when it's a co-funded project, to actually get it on the books and understand that we put in the actual revenue aspect and the full expenditure and identify it as a multi-year project. So we have other projects that have been treated the same. Generally, bridge renewal projects, RLCIP or road, yes, I remember the acronym, but not necessarily all the names. But a fair portion of those are multi-year projects, bridge renewals up to 3 years, and National Heavy Safety and Productivity Program is the same. So, and with that, yes, it's. Look, I'll probably throw to Oliver to which is the best way to identify it, but I think in this particular case it was decided that we put the entire amount, but make a note that we reduce what's on the approved long-term financial forecast for this particular asset class. When we put the 10-year program together, it has an $800,000 reduction for next year.
thank you.
Councillor Enoch?
Thank you, Mayor. I just wanted to go back to the Bethesda Business Park item that we touched on before, acknowledging there's 1.3 million additional expenditure. Can I ask what is the value of the Bethesda Business Park development project now, and what is the value of council's contribution to that project?
I can answer that. It's anticipated that it'll be just shy of $13 million when complete, so 12.933 million. As I mentioned earlier, there was a grant of $5 million, which council's then contribution would equates to 7.933 million, so just shy of $8 million.
Still a pretty good investment as far as ratepayer funds go.
Thank you, Mr. Mayor. On page...
Wait, we're still going. Are we still not going through my dot points there? Yeah, we're not up to. We're still going through these capital expenditure increases.
Okay. All right.
Yeah, okay. The next one is Kerry Road. Look, we've already had to defer one element or project on Kerry Road, and this is basically to complete the scope that was already identified within one of the aforementioned funding regimes. So the reality of it is the cost of material, cost of plant and labour has gone up quite considerably, as well as this particular project. Some of it was impacted by wet weather. So that's an increase to finalise a specific section of road. Now, this work, some of it had started last financial year. The interesting part is once you open up a section of road, you can't always stop dead set in a curve. You need to actually stop where it's a safe place to join back onto the existing road. So we did look at scaling back the scope, but it just wasn't a good alignment given the nature of the road. So there's a request for an additional $387,000 to complete that scope. The next one on the...
Just on that question, what is the traffic count on Kerry Road?
Depends what section of the road you're looking at. At that particular location, it's several hundred vehicles a day. It also...
Hundred, not thousands?
Yeah, hundreds. And we also look at the number of heavy vehicles that utilise the road as well. So we have an overlay of percentage of heavies or the number of heavy vehicles, and that number escapes me at this point in time, but the percentage is quite considerably higher than a number of other roads given its linkage to the farming community in that vicinity.
So a supplementary question is, what is the total amount of expenditure which will be spent on Kerry Road this year and in next year's program as well?
Something I'll have to take on notice. I don't have all those figures with me here. It would take me wouldn't take me a huge amount of time, but it would take me some time to get an exact number.
Could that be reported to back to the next meeting? If you're taking it on notice.
Yes, I could report that to the next meeting. Yes.
Right. Thank you.
Vonda Youngman, yes, I'm happy to go. Vonda Youngman, realistically, there's two parts to this. I have some notes here. For Vonda Youngman, there's around approximately $86,000 to actually undertake works with regard to improved PWD or people with disabilities access, which there was when the project was first analysed, there was the scope didn't actually address the ramp slope appropriately, so there was additional works to tie that in to a PWD car parking space. So there's some additional costs associated with that, as well as every other project, and I feel a bit like a broken record here, there are additional costs as a result of the market that we're living in at the moment. The team have certainly done their best in actually what we've done with this one. We've actually pulled it in as a day work schedule. When we got contractor rates were reasonably high as a result of contractors needing to manage the risk. So we took on some of that risk ourselves by utilising day rates. Also, there's part of the scope of the project was facade improvements. That's certainly been scaled back, but still understand that to complete the project in its entirety it would be appropriate to have the car park redone, the PWD sorted, landscaping, and some minor facade works. And the facade work portion at this point in time is approximately $360,000 of the $387,000 listed there. The next item, $200,000 refurbished Tamborine Mountain Library. As you all know, we're refurbing what was the former IGA building and Main Street in Tamborine Mountain. One thing that we didn't realise when we started refurbing was the need to, when we looked at the actual power box or the whole arrangement for the electricity where it connects onto Energex supply, it doesn't quite conform with what would be appropriate, and the estimate to actually get it rebuilt and placed in a format that is appropriate is going to come out to this figure of $200,000. So that's the switchboard and full upgrade of that connection. So that's that particular item.
Is it worth adding that there was an assessment done that it would be inappropriate to charge this to the body corporate because of just due to the library expansion works?
Yes, so the reality of it is that a portion of it should really go fully through the body corporate, as we're 93% of the body corporate, and there are already costs associated with the current tenant or the remaining tenant for other improvement works that have been identified for the building, and as a result of our works, this upgrade is required. It was thought unreasonable by officers, hence to request the 18 or 17 odd thousand dollars from the other occupant to contribute to these works. So we put forward the council fund that's in its entirety.
Just a question on that. Do we have a third party do a building inspection report on the facility before we signed the contract, or was that due diligence done by ourselves?
I believe we did. I'm going off my memory again. I should refer to taking that one on notice, but I'm reasonably comfortable today to a full report on the building and its functionality.
I can probably add to that, Chris. If you recall, Council had looked at purchasing this prior to this particular project, and there was quite a fulsome report done at that time that identified any of the issues that would need to be addressed. And when my officers worked with ANES to prepare the grant for this library project, those were taken into consideration, and I also believe were taken into consideration as a part of negotiating the sale price.
Oh, that's good, but if you take it on notice, can you also bring that one back to the next meeting as well?
Yes, I can. And the last one there is realistically around identified need for 2 additional vehicles to our fleet, which come in around $45,000 each.
Thank you.
Just in relation to the last one, when Council considered all the new initiatives in the current budget, I believe those 2 staff were identified and a budget figure presented. Was it not envisaged at that particular time that these 2 staff members would also incur capital expenditure on new plant and vehicles?
I'm happy to take that question, Councillor. No, the staff have been part of our establishment. This is really about ensuring that we have an appropriate fleet to service the operational requirements of the organisation, and by nature of those employees' roles, they would be allocated use of those fleet vehicles. They would form part of the pool during the working day when those employees are on site.
Just a supplementary question on that. I see in the capital budget that 5 new pool vehicles were already allocated at the time of the budget, but these 2 weren't envisaged. So it wasn't envisaged that these officers would have ability to use the pool vehicles that we were also purchasing at the time of the budget adoption.
I can't comment on that.
Of the 5 vehicles, I believe 2 are specific vehicles fitted. Or may even be 3 of those vehicles are fitted specifically for a particular area. I believe one is survey, another one is animal management, and the third one escapes me. So they will be pool vehicles, but pool vehicles within those sections of council. So the reality of it is not generally fit for purpose for general pool vehicles.
Thank you. Further, Councillor Enright, sorry.
Thank you, Mayor. More of a general question. Considering the capital expenditure, the vast majority is the result of natural disaster events and the funding related to the restoration work. Given what we know now with weather impacts and supply chain challenges, and that the restoration work will take some time to deliver, what safeguards are available to Council for potential future increased costs to complete these restoration works?
Thank you for the question. The majority of the restoration works, and not all, I will stress not all, the majority are subject to actual costs on delivery. The impact will occur is that we actually come up with a submission value and we get paid on completion percentage on the submission value up until 90% of the approved value. So council may be in a position if, say, again, I'll use $100, we get $30 up front, we keep claiming up until we get $90. Once the Cure sign off, regardless of whether it's cost us $120 to deliver, we may be holding an amount of money in that stage. If it becomes untenable, or we get ourselves in a position that our cash position is not that flash as a result of that occurring across a number of claims, there may be the opportunity for a cash advance application. However, there's a whole process, and that then adds another dimension to how you equip each of the projects. So I say the majority of the program is that way. There are some aspects. Betterment is, in some instances, is a tied contribution, so we need to be quite certain on the scope of work that betterment's going to fulfil, as well as some of the ongoing additional grant opportunities under Cat C and D, or Category C and D, sorry, of our activation. Some of those are a lump sum or a fixed price grant. So we've been very cautious in identifying and understanding what cost overruns would be could be seen in those works. So, and look, as a percentage, that is a lowest percentage of the overall that's been allocated.
So further to that, for clarification, if I may, so using that example that we thought it would cost $100 to repair, we got to 90, and then we realised it's going to cost 120. Then there are avenues, or what is the process from there? So
we know that we're getting to 120 well in advance. We do a monthly forecast for each of the submissions of what is remaining and what the costs may be, and that's at submission level. No, and look, I should dig up a scatter graph of our previous unit rates for unsealed roads. It was about 1,000 odd unit rates, and I don't think any of the dots actually lined up. We tried to put a line through it, the volume and length, and yes, there's a whole heap of variances in there, but thankfully our average unit rate covered the majority of those aspects, or hit around about the 80 odd % of what was there. So, but I do acknowledge that the unit rates that are used within the submissions, we do get an opportunity to update those, and we have been updating those relatively regularly. However, it's trying to ascertain the actual cost of delivery at the moment in some aspects is quite complex.
Thanks for that clarification. That's good.
Thank you. Further clarifications, Councillor Swanborough.
Thank you, Mr. Mayor. Yes, on page 1 of 24, let's have a look. It's probably page 281. Whilst we did hear an explanation of the revenue and expenditure, and at a macro point of view, and we said that it came in at roughly $164 million deficit, which accounts for the...
I don't think that was 164 million, Councillor. I think you're in error.
Thousand. I'm thinking and reading at the same time. 164,000.
It was a surplus.
Deficit, which is what the surplus was, roughly the surplus was projected to be. It says on that page, an increase in operating expenditure is largely due to expenditure associated with additional operating grants and subsidies. Revenue included in the budget review, $2.63 million. The balance of the proposed movement is due to various adjustments across Council's program, resulting in an increase totalling $1.077 million. Is there transparency here in relation to what is in that $1.077 million of operating expenditure? Is there a place where we can go and see what that increase in operating expenditure was across the organisation?
Yes, a couple of points there. So the 165 relates to the impact on the position of council. Now you recall on the comprehensive income, a reduction in cash. It's still resulting on council showing a modest $18,000 surplus or a balanced budget. With respect to details around the revenue and expenditure side of things, I'd refer councils to page 285 of the report. So these are complementary notes to the statement of comprehensive incomes. You can see there where it details the notes and the particular, just on the screen now, the itemised line items that relate to from the revenue side of things as well as the expenditure side of things. Is that what you were sort of referring? That in general sense collates to what those differences are when it comes from a revenue and expenditure.
Right.
For example, we did say that the bulk of it, as you rightly said, $2.063 million of the $3.139 million relates to operating expenditure with grants. You can see there where note 6, employee expenses, there's an additional $249,000 for grant-funded programs being reflected in employee expenses as just one item, and then that details all the other changes that relate to $1 million, to the total $3.139 million.
So the only thing there in operating is employee expenses. You've got capital grants, operating grants and subsidies. You've talked about that. Other revenue, the other things are all revenue.
Yeah. Further down the page, Sharon, note 7, which is your materials and services side of things.
So in that materials and services, do we have how much of that $1 million odd is in material and services?
Sorry, Sharon, if you go back to page 284, that provides that summary in the statement of comprehensive income. So on the right-hand side, it shows the movement. If you scroll down a little bit, down the expenditure, basically, there's $706,000 in employee expenditures and $2.434 million in materials and services. Is that on the far right? And then the relevant notes then give you the relevant breakdown to those amounts. Does that?
So what I'm looking for, and without divulging anything confidential here, is that because I really don't know whether this is confidential or not, but you can tell me, so I'll be circumspect. When council was advised about the cost of defending the pig and calf sale yards in court, a figure was given to council. I don't know whether it was in a confidential briefing or in a public meeting, or it's been divulged in the fine print in another financial report anywhere. I can't remember. It's almost impossible to tell and find out. We suspect or know that that expenditure is probably 4 times that amount as originally advised to council. Whereabouts does that show in these statements that we have in front of us at the moment?
Sorry, Chris is...
I think I'll take that particular question on notice. The reality of it is we're not quite in a position to actually speak publicly about the outcomes of the court case, as they're still an appeal process that ends very shortly by other parties. So at this point in time, there is planned for either the first meeting in January or the only meeting in January or the first meeting in February as an opportunity for a detailed report to come forward to council, of which would include the finalised cost of the undertaking of that, as well as a prediction of future costs, associated to the resolution that council had on the books at the time.
So I can assume that the bulk of that expenditure has already been made, and there may be even more expenditure coming up. So if the General Manager of Sustainability can advise, do you intend to capitalise those expenses? Is that why they're not showing here? Is that in accordance with accounting standards if that's the case, or is this an operating expense which we don't know where it appears in the statements at the moment?
That's correct. One, it's not a capitalisable item because it's not attributed to an asset, so it would be expensed. Currently, there would be allocations within existing operating budgets that relate to external legal advice and such. So, we're only 3-4 months into the financial year. So effectively, any costings from that matter would be attributed to that overall budget. Now, at some point in time, we've still got 7 months of the year to go through. Fingers crossed, if there's no other legal matters, then there should be no need to adjust. But you'd think that if the expenditure associated with a matter that was raised eats up into the normal operating budget, as Chris indicated, a further update to council showing that may require a further consideration and then reflective of the true cost of that matter to finalise. Once it's finalised and we know what the exact extent cost is, then it's hard. It's hard to just put, we'll just put so much in today and then wait until that future end. So at the moment, it's being put against the overall legal budget, and as such may need consideration at some point in time because other legal matters may or may not come up during the rest of the financial year.
Thank you. Any further clarifications, councillors? Councillor McConnell?
Yeah, just going back to the expenses and the employee expenses, an extra 706. Can the GM People and Strategy just advise what our current vacancy rate at the moment is, and how many positions?
At last, I think towards the end of November, we had made these assessments. Our current vacancy rate is approximately 17%, and discussions across South East Queensland councils indicate that that's pretty common. That's about the average. The Queensland Auditor's Office also indicated that was their finding too, as they spoke to all of the councils, that was about that equates to 70 odd vacancies.
And how is their work currently being done?
So there's a mixture of strategies, of workforce strategies to resolve, to address those vacancies. In some cases, you will see in budget amendments transfer of funds from employee expenses to materials and services, and in those cases, we may engage via a procurement agreement resources to perform tasks that we would otherwise have completed in-house. In other ways, we may engage casual labour to perform those tasks, and sometimes we move people. We second existing employees to different roles to create backfill for those positions.
So how many of those 70 plus positions aren't filled at the moment through other means?
Yeah, we can't answer that, councillor. We don't have those statistics available to us in terms of the way we record occupancy against our establishment at this point in time. We are working to fix that.
Okay, thank you.
Councillor Enright?
Yeah, one more question. Thank you, Mayor. Page 297. And it refers to the grant-funded black spot funding, and there's a increase provided there. Could you please expand on the increase in the capital grant funding for the black spot funding, please?
I'm going to talk about wombats again. So thank you, councillor, for the question. The reality of it is we put forward 5 projects, and we were successful in gaining grants to undertake five projects. Two of the projects were reviewed by the funding authority, and there was a change in between when we put the scope together to when the finalised plans were reviewed. There was a request to update the pedestrian crossings to wombat crossings. I think I've mentioned them previously. With that, there was a need to look at the drainage impacts as a result of the raised crossing, as well as look at the need for lighting, which I believe the majority of those where they're being installed, the lighting was required. We then went out to tender as a package for all 5 locations, and as a result of the scope change plus the current climate we're in, there was quite a considerable increase in cost to deliver those 5 projects. We went back to the funding body and were successful in receiving additional funds to meet the then increased cost to provide those 5 projects. So it was a good outcome. We really thought at the end of the day that we'd be either saying goodbye to a portion of the funds projects to fund the remainder, but we went and asked the question, and we're very, very happy to receive the additional dollars and the work has been issued to a contractor, and some is starting now and the remainder will start early in the new year.
And just to clarify, it's 100% funded by the federal government.
Yes, that's correct.
Thank you, Councillor. Thank you, GM. Any other questions? Come to the recommendation, please.
I think just on that, Mayor, just a further note, I did indicate about the unanticipated increase or decreases, but those that are keenly playing an eye every first Tuesday in the month, obviously the news as the Reserve Bank have increased. So, reflective in this revised budget was an increase in about our interest revenue of additional $500,000. Today's increase obviously may probably require further amendment at a future time, but it's certainly news in there. But thank you for that consideration and those commentaries towards this matter. In saying that now, Mr Mayor, the recommendation being considered for Council today is that in accordance with sections 169 and 170 in brackets 3 of the Local Government Regulation 2012, Council adopt the 2022-2023 September Budget Review as outlined in the 1. Revised Statement of Comprehensive Income for 2022-2023 through 2024 to 2025 inclusive. 2. Revised Statement of Financial Position for 2022-2023 through 2024 to 2025 inclusive. Revised Statement of Cash Flows for 2022-2023 through 2024-2025 inclusive. 4. Revised Statement of Changes in Equity for 2022-2023 through 2024-2025 inclusive. And 5. Revised Relevant Measures of Financial Sustainability.
Councillor Seeker Mover. Councillor Enright. Any further questions? Any further discussion? Seeker Seconder. Councillor Chalk. Councillor Enright, you wish to speak?
Thank you, Mayor. I'd like to commend the General Manager and his team for bringing forward the September Budget Review, given the work that it has taken to bring that under challenging times. It's a great update on how things are progressing. There used to be a word used, unprecedented, that was used very much over the last 2 years. Sadly, it's not so unprecedented these days, and we're having to adjust and be flexible to allow us to deliver the services to our community while managing the challenges that come with doing that. So I commend all of the staff for the efforts in delivering these programs under these continual challenging times. Thank you.
Thank you. Anyone wishing to speak against? Seeking leave to speak additionally? Put the motion. Those in favour? That's carried unanimously. Thank you, councillors. That's the end of the agenda before us today. So thank you for your consideration. Thank you to those who've stayed with us in the digital gallery, as the physical gallery is no longer with us. Thank you to officers for their participation. There are some big pieces of work that have been signed off there today. And given that this is in fact our last meeting for the year, in closing the meeting, I will wish all those listening in the very best for the Christmas season. Councillors, I bid the same to you and to the executive team and your officers. It's been a hard year. It's been a challenging year for, as we've talked about so often, about many of the things that are being dealt with. But as a region, we have continued to shine. Our businesses have continued to shine. Our performance, the performance of council has been demonstrated as continuing to kick goals, even in the context of having shortages of staff and being in a really challenging space for the maintaining of our team. 2023 will offer further challenges, but I wish everyone a safe and blessed Christmas and a restful time where possible. Hopefully I don't have an LTMG standing up for Christmas, and that we can return in the new year to continue to celebrate being in the richest place on earth. And with that, I draw the meeting to a close at, I think that's 2:46. Thank you.